What if justice didn't blind but winked? Behind the mahogany benches, powdered wigs, and gavels that promise order lies a darker lineage: corruption, conspiracy, and the quiet unraveling of truth by those sworn to protect it. From hanging judges who sold verdicts to defense attorneys who sold souls, these aren't the famous miscarriages of justice they teach in law school. They're the ones buried in courthouse basements and sealed in manila folders marked classified. This is the hidden history of the scales tipped by gold, tilted by power, and broken by those who wore the robes. 30 cases, one unspoken truth. Justice isn't always blind. Sometimes it just looks the other way. This is the story of the 30 most corrupt court cases you never heard about. Before we dive in, make sure you're subscribed. This rabbit hole goes deep, and you won't want to miss what's next. Drop a comment and tell us where you're watching from and what time it is. 2 a.m. in Chicago, sunrise in Sydney? We see you, insomniacs. Let's begin. 1. William Garrow's first case. Imagine a courtroom so corrupt, so enamored with its own performance of justice, that even the defense attorney had to lie about believing in it. That courtroom was the Old Bailey in 1783, and the case was Crown versus Harrison, a trial that should have lasted an hour, but instead exposed a century of judicial rot. William Garrow was not supposed to be there. Defense attorneys, in the modern sense, barely existed. Accused thieves were expected to defend themselves stammering and illiterate against prosecutors who'd perfected the art of conviction. The system worked beautifully, assuming your goal was filling transport ships to Australia, not finding truth. And in 1783 London, that was exactly the goal, because every convicted criminal meant money. Transportation contracts, court fees, a percentage of confiscated goods. Justice wasn't blind. It was an accountant. Garrow, young and absurdly idealistic, had been hired by Harrison's family to observe the proceedings. Nothing more. But when the prosecutor presented the stolen silver, supposedly found in Harrison's rooms by a Bow Street runner named Thomas Kelly, Garrow noticed something the judge deliberately ignored. The silver didn't match the theft report. Wrong pattern, wrong maker's mark, wrong everything. He stood. He objected. And in doing so, he accidentally invented cross-examination. The judge, Justice Francis Buller, was not pleased. Buller was a man whose face had settled into the permanent expression of someone digesting bad meat. He'd presided over the Old Bailey for 6 years, maintaining a conviction rate that would make modern prosecutors weep with envy. 93%. Not because he was thorough, but because he was efficient. And efficiency, in Buller's courtroom, meant never questioning the Bow Street runners, never allowing defense witnesses, and never, under any circumstances, letting facts interfere with a good hanging. But Garrow had facts. And worse, he had questions. Under cross-examination, a concept so novel the court stenographer didn't know how to record it, Runner Kelly's story crumbled like wet parchment. The silver had been found in a drawer Kelly claimed was locked, but Harrison had no key. The silver matched pieces stolen from a different house entirely, one where Kelly had also been investigating. And Kelly, when pressed about his financial situation, suddenly recalled he'd recently purchased a new horse, new boots, and paid off substantial gambling debts. The courtroom fell silent, not the silence of revelation, but the silence of inconvenience. Buller tried to dismiss the questions as improper. The prosecution objected on principle. But Garrow, emboldened by the jury's suddenly interested faces, kept pushing. He produced witness testimony from neighbors, from locksmiths, from the actual victim of the theft Kelly had investigated. The silver hadn't been stolen by Harrison. It had been planted by Kelly, likely pieces of evidence he'd pocketed from previous cases, ready to be deployed whenever he needed to pad his arrest record. Because Kelly was paid per arrest, and Buller was paid per conviction, and the transportation companies were paid per body loaded onto ships bound for Botany Bay. It was a vertical integration of injustice, oiled by poverty, and operated by men in powdered wigs who called it law. Garrow won the case. Harrison walked free. The courtroom erupted in applause, apparently unaware that celebrating justice shouldn't feel revolutionary. But the victory was Pyrrhic, ornamental. Kelly was reassigned, not prosecuted. Buller issued a stern warning about disruptive questioning techniques and continued sentencing defendants at his usual rate. The system absorbed the embarrassment the way marble absorbs spilled wine, with a slight darkening that fades by morning. Within a week, the Old Bailey had convicted 3 more people on evidence provided by Bow Street runners. Within a month, Buller had forgotten Harrison's name entirely. For every defendant Garrow saved over his long career, a dozen more were sold to the colonies on fabricated evidence. The judge retired wealthy, his pension fattened by years of reliable convictions. Kelly got a promotion. And justice? Justice learned to keep its receipts hidden. But Garrow wasn't the first lawyer to realize the bench was rotten. A century earlier, another trial had set the precedent for judicial corruption, not in England, but in the American colonies, where a judge didn't just tilt the scales, he owned them. His name was Nicholas Bayard, and the year was 1702. Nicholas Bayard, they called it treason, but the only thing Nicholas Bayard betrayed was his business partner's bank account. In 1702, colonial New York, that was enough to get you sentenced to death. Bayard was everything the Crown supposedly valued: wealthy merchant, colonial administrator, nephew of Peter Stuyvesant. He'd helped negotiate treaties, manage trade routes, and generally kept New York's economy from collapsing into the Hudson. But he'd also signed a petition. A polite, carefully worded petition suggesting that perhaps Lord Cornbury, the colonial governor, might be embezzling funds, which he absolutely was, and possibly mismanaging the colony, which he definitely was doing while dressed in his wife's gowns. Cornbury's response was efficient. Arrest Bayard for treason. The charge was absurd on its face. Treason required levying war against the crown or giving aid to enemies. Bayard had done neither. He'd signed a piece of paper asking for governmental reform, an activity that would become constitutional 75 years later, but in 1702 was whatever the governor said it was. And Cornbury said it was treason, capital treason, the kind that ended with a rope and a drop. The trial was scheduled for March 1702, presided over by Chief Justice William Atwood. If Bayard had enemies, Atwood was their president. He owed his appointment entirely to Cornbury and had business interests that directly competed with Bayard's shipping ventures. Asking Atwood to judge Bayard fairly was like asking a wolf to referee a lamb competition. The jury was handpicked, 12 men, all Cornbury appointees, all with financial ties to the governor's patronage network. The prosecution presented the petition as evidence of seditious conspiracy. The defense tried to argue that petitioning wasn't treason. Atwood interrupted to clarify that in his courtroom, petitioning absolutely could be treason if the governor felt threatened by it, which seemed like circular reasoning, but was apparently settled law. Witnesses testified to Bayard's excellent character, his loyalty to the crown, his decades of service. Atwood dismissed their testimony as irrelevant. Character wasn't on trial. The petition was, and the petition, Atwood ruled, spoke for itself. It was critical of the governor. Therefore, it was seditious. Therefore, it was treasonous. Therefore, Bayard would hang. The verdict took less than an hour. Guilty. Sentence to be carried out immediately. Bayard's family managed to delay the execution through bureaucratic appeals, sending desperate letters to London describing a colonial governor so corrupt he'd turned courtrooms into personal vendetta chambers. Queen Anne reviewed the case in 1703 and reportedly remarked that if signing petitions was treason, Parliament would be empty. She issued a full pardon. Bayard lived, but the precedent festered. For another 70 years, colonial governors would use courts as weapons, judges as hired muscle, and treason charges as convenient solutions to political inconvenience. Courtrooms weren't places where justice was decided. They were places where power was performed, scripted, and staged for an audience that didn't get to vote on the ending. Colonial corruption was just warming up. Across the Atlantic, back in London where these legal traditions were born, one judge was perfecting the art of mass conviction. They called him the hanging judge, and his courtroom wasn't interested in guilt or innocence. It was interested in quotas. His name was George Jeffreys. 3. Judge George Jeffreys and the Bloody Assizes. If there was ever a man who turned judicial robes into executioners' hoods, it was George Jeffreys. The hanging judge didn't earn his nickname through careful jurisprudence. He earned it by sentencing over 300 people to death in a single judicial tour, and then selling pardons to the highest bidder. The year was 1685. The Duke of Monmouth, illegitimate son of Charles II, had attempted to seize the throne from his Catholic uncle James II. The rebellion failed spectacularly, ending at the Battle of Sedgemoor with Monmouth's execution and his supporters scattered across the West Country. What followed wasn't justice. It was extermination with paperwork. James II dispatched Jeffreys, then Lord Chief Justice, to conduct trials throughout Somerset, Dorset, Devon, and surrounding counties. The mission was clear: make an example, terrify the population, prove that rebellion against the crown meant death and not the quick kind. Jeffreys embraced the task with the enthusiasm of a man who'd found his calling, which in his case was systematic judicial murder. The Bloody Assizes, as they came to be known, were trials in name only. Jeffreys moved through towns like a harvesting machine, processing defendants at a rate that made mockery of due process. Dozens of cases per day. Evidence was optional. Defense was discouraged. If you lived in the region, if you were male and of fighting age, if your name appeared on any list compiled by nervous loyalists trying to curry favor, you were guilty. The only question was whether you would hang, get transported, or occasionally, if you had enough money, walk free. Because behind the theatrical brutality was a remarkably efficient business model. Jeffreys had a price list, though it was never written down. Death sentences could be commuted to transportation for the right sum. Transportation could be reduced to fines. Fines could be negotiated down to warnings. The system was flexible, responsive to market conditions, and extraordinarily profitable for everyone except the defendants. Witnesses reported seeing Jeffreys conduct trials while visibly intoxicated. His face, already ruddy from years of heavy drinking, would flush deeper red as he shouted at defendants, mocked their accents, and interrupted any attempt at defense. He called one woman a lying whore from the bench. He told a minister that he would hang him if it were the last thing he did on earth. He reportedly laughed when sentencing groups of young men to be hanged, drawn, and quartered, a punishment so barbaric that even hardened executioners requested hazard pay. But the brutality had purpose. The more harsh the sentence, the more valuable the commutation. Families would scrape together everything they owned to buy their sons' lives back from the crown. Jeffreys would accept the payment, commute the sentence to transportation, and pocket a percentage. The transportations themselves were lucrative. Ship owners paid for cargo, and convicted criminals were cargo. The entire apparatus hummed with financial efficiency, lubricated by terror and blood. Contemporary accounts describe Jeffreys' physical state deteriorating throughout the assizes. His hands shook. His speech slurred, not just from drink, but from something deeper, a kind of moral exhaustion that manifested as rage. By the time he returned to London, he'd sentenced an estimated 320 people to execution, 800 to transportation, and countless others to whipping, fines, or imprisonment. He'd also made a fortune. Exact figures were never recorded, but property records show Jeffreys purchasing substantial estates in the months following the assizes. The drinking intensified. Friends noted his increasing paranoia, his belief that he was being followed. watched, judged, which, ironically, he was. When James II fled England in 1688 during the Glorious Revolution, Jeffreys tried to escape as well, disguised as a sailor. He was recognized in a Wapping tavern, arrested, and imprisoned in the Tower of London. He died there in 1689, officially of kidney failure. Unofficially, of the poetic justice variety, where a man's body finally matches his soul. His liver was destroyed, his kidneys failed, and his mind, according to Tower guards, had begun to unravel. He ranted about the defendants he'd sentenced, claiming they were innocent, then insisting they deserved worse. The alcohol had stopped working years earlier. By the end, it was just keeping him conscious enough to experience his own decay. Jeffreys left behind a legal precedent that normalized judicial murder for profit. The bloody assizes became a reference point, a cautionary tale, but also a template. Future judges would study his methods, not with horror, but with professional curiosity. How efficient, how profitable, how utterly protected by the crown. But even Jeffreys couldn't match the sheer audacity of judicial corruption happening across the Atlantic, where one Chief Justice didn't just take bribes. He kept a ledger, with prices, itemized by offense. Enter Thomas Burke. 4. Chief Justice Thomas Burke. Most corrupt judges have the decency to hide their bribes. Thomas Burke published a price list. Vermont in 1784 was barely a state. It had declared independence from both New York and New Hampshire, fought off British invasion, and established its own government through a combination of stubbornness and geographical isolation. What it lacked was institutional memory, legal precedent, or anyone who particularly cared about judicial ethics. Into this vacuum stepped Thomas Burke, appointed Chief Justice of the Vermont Supreme Court, a position that came with prestige, a modest salary, and apparently unlimited entrepreneurial opportunity. Burke was Vermont's first Chief Justice, which meant he could define the role however he wanted. What he wanted was income. Judicial salaries were paid irregularly, often in depreciated continental currency or promissory notes from a state treasury that barely existed. Land, however, was everywhere, and land disputes were constant. Settlers from New York claimed titles granted by that state's colonial government. Settlers from New Hampshire held competing grants. Local Vermonters insisted both were invalid. The result was a legal chaos that required judicial resolution. Burke resolved it by auction. His system was elegant in its simplicity. Land disputes had fixed prices depending on acreage and value. A favorable ruling in a case involving 100 acres might cost £50. 1,000 acres, proportionally more. The price was negotiable, the outcome guaranteed. Payment could be made in cash, land grants, livestock, or promissory notes backed by the disputed property itself, which created a delightful circular economy where Burke was essentially betting on his own rulings. The remarkable thing wasn't that Burke ran this system. The remarkable thing was that he wrote it down. A ledger discovered years after his death detailed transactions with the specificity of a merchant's account book. Names, dates, amounts paid, verdicts delivered. It read less like evidence of corruption and more like a business prospectus, which in Burke's mind it probably was. This wasn't crime. It was Vermont's informal economy, where the line between governance and commerce had never fully formed. Other justices on Vermont's Supreme Court appear to have participated, though their involvement was less thoroughly documented. Cases were routinely decided before evidence was heard, sometimes before parties even arrived in court. Lawyers learned to approach the bench not with arguments, but with offers. The entire state legal system operated like a particularly well-organized protection racket, except the thing being protected was property rights, and the racketeers wore judicial robes. Burke died in 1802, respected and wealthy. His ledger was discovered during a state settlement, causing brief scandal among Vermont's increasingly legitimate government. By then, Half the land titles in the state had been decided by auction, not argument. The records were quietly archived, then lost, then possibly destroyed. Easier than invalidating every corrupt verdict? Easier than admitting Vermont's entire legal foundation was built on purchased justice. But Burke's written records were almost quaint compared to what happened when corruption didn't just bend the law. It erased people from existence. In 1811 Philadelphia, one prosecutor discovered he could make witnesses disappear. Literally. 5. The conspiracy against Samuel B. Davis. Samuel B. Davis had 17 witnesses who could prove he was 40 miles away when the murder happened. By the time his trial ended, 12 of those witnesses were in jail. 3 had fled the state, and 2 were dead. The prosecutor called it justice. The case began in 1811 with the death of a Philadelphia merchant named Thomas Willing. Robbery gone wrong, according to the initial investigation. Davis, a local tradesman with debts to Willing, became the primary suspect through logic that was either sloppy or strategic, depending on how cynical you were about Philadelphia's legal system. The prosecutor, Alexander Addison, was very cynical, also very ambitious, and murder convictions launched political careers. The problem was evidence. Davis had been in Lancaster the night of the murder, attending his sister's wedding. 17 people could testify to this. The solution, from Addison's perspective, was to make those 17 people unavailable. It started with arrest warrants, small charges easily fabricated, disturbing the peace, theft of items that had never existed, failure to appear for hearings that had never been scheduled. Witnesses received summons, showed up to testify, and were immediately arrested on unrelated charges by men who'd been waiting specifically for them, with warrants signed days earlier by judges who were reportedly dining regularly with Addison. 12 witnesses ended up in Philadelphia's Walnut Street prison before Davis's trial even began. The charges were vague, the bail impossibly high, and the processing deliberately slow. They would remain imprisoned through the trial, unable to testify about being 40 miles away, because they were currently 3 blocks away, locked in cells. 3 more witnesses fled. Anonymous threats, delivered by men whose descriptions matched court bailiffs. Suggestions that perhaps Lancaster had better opportunities, safer opportunities, than testifying in Philadelphia murder trials. They took the suggestion. 2 witnesses died. One from injuries sustained during arrest, officially ruled an accident. One from illness contracted in prison while awaiting his own trial on charges that would later be dismissed for lack of evidence after Davis was dead. With the alibi witnesses neutralized, Addison proceeded to construct an alternative reality. He produced witnesses who claimed to have seen Davis near Willing's shop on the night of the murder. These witnesses were strangers to Philadelphia, brought in from other districts, compensated for their testimony through methods that weren't recorded but can be inferred. Their descriptions of Davis were vague. Their timelines contradicted each other, but they were present, sworn and unchallenged. He presented documents, letters supposedly written by Davis planning the robbery, ledgers showing Davis's debts, financial records that would later be revealed as forgeries, but which in 1811 looked official enough to convince a jury that already believed Addison wouldn't bring charges without cause. The defense attorney, hamstrung by absent witnesses and fabricated evidence, did what he could. He pointed out inconsistencies. He questioned the prosecution's witnesses. But when all your evidence is 40 miles away or in jail, and all the prosecution's evidence is in the courtroom wearing respectable clothes, the jury doesn't need long to decide. Davis was convicted. He was hanged in 1812. The truth emerged in 1819, buried in a deathbed confession from a court clerk named Benjamin Morris. Morris had helped forge the documents, helped coordinate the witness arrests, helped maintain the fiction that this was legitimate prosecution rather than orchestrated murder. The guilt apparently became unbearable. He confessed to a minister who convinced him to write it down, who then sat on that written confession for 3 more years before anonymously sending it to a newspaper. By then, Addison had retired with honors. The witnesses who'd been imprisoned were never compensated. Several had died in custody. And Samuel B. Davis remained officially and eternally a convicted murderer, because posthumous exoneration would have required admitting the system had deliberately killed an innocent man. Easier to let the record stand. American judicial corruption was still learning from its European masters. And in 1820s London, one judge had perfected the art of conviction for profit to such a degree that his courtroom became known as the slaughterhouse. His name was Judge Gascoigne. 6. Judge Gascoigne's quota system. Justice is supposed to be blind. Judge Gascoigne made sure it was also deaf, at least when the defense was speaking. London in the 1820s had privatized its prison system, which turned out to be roughly as good an idea as it sounds. Private contractors built and operated facilities, receiving payment per prisoner per day. The more bodies in cells, the more revenue. The system required a steady supply of convicted criminals to remain profitable. Judge Gascoigne, presiding over the Old Bailey, was happy to provide. His courtroom operated with the efficiency of a factory. Cases moved through at remarkable speed, defendants processed like inventory. What made Gascoigne unique wasn't his conviction rate, though at 94% it was impressive. What made him unique was his method. He had perfected the art of the directed verdict, not through legal reasoning, but through time management. Defense witnesses were scheduled for the end of the day. Gascoigne would ensure that prosecution took longer than expected. Redirect examinations stretched into late afternoon. Recesses were called for increasingly trivial reasons. Lunch breaks extended. By the time the defense was prepared to call witnesses, Gascoigne would glance at the clock and announce that the court was running late, that unfortunately there was insufficient time to hear additional testimony, and would the jury like to deliberate now or after a brief recess? The jury, eager to go home, would deliberate. Quickly. When defense attorneys objected, Gascoigne had a practiced response. He'd already given them ample time. The prosecution's case was complete. What more did they need? The facts were clear, the evidence presented, and the court had other cases scheduled. Justice delayed was justice denied, and he wouldn't let bureaucratic inefficiency stand in the way of a verdict. Sometimes defense witnesses would arrive before being called. They'd sit in the gallery, ready to testify. Gascoigne would make eye contact, note their presence, and then proceed to run out the clock anyway. The message was clear. Your testimony wasn't relevant because it wouldn't be heard. Court clerks kept records. They noted the pattern. Defendants represented by wealthy solicitors somehow had longer trial days, more recesses, more time for witnesses. Defendants with court-appointed representation found their cases concluded by mid-afternoon, before anyone inconvenient could speak. The correlation between wealth and trial length was statistically significant. The correlation between trial length and acquittal was even more so. Gascoigne's income wasn't directly tied to convictions, but his reputation was. Prison contractors knew which judges were reliable, which courtrooms produced steady supply. Invitations to dinners followed, gifts discreetly given, recommendations for better appointments. The economy of judicial corruption didn't require explicit bribes when the incentive structure was this well designed. Reform-minded members of Parliament eventually noticed. An inquiry was launched in 1830, documenting Gascoigne's methods in parliamentary language that managed to describe systematic injustice without ever using the word corrupt. The report suggested better time management, more consistent scheduling, and perhaps allowing defense witnesses to testify. Revolutionary concepts? Gascoigne retired in 1831 with a pension and parliamentary commendation for his efficient courtroom management. The 3,000 people he'd convicted under this system were never reviewed. Efficiency, after all, was what the system valued most. Still values? Most. just with better scheduling software. Gascoigne's quota system was transparent compared to what judges could do in secret, especially in America's frontier territories, where court records could simply vanish into the dust. Just ask anyone who faced Judge Roy Bean. That is, if you can find their trial records. 7. Judge Roy Bean. Judge Roy Bean once tried a dead man, found him guilty, and fined him $40 for carrying a concealed weapon. Then he kept the money. That was one of his more legitimate trials. West Texas in the 1880s was a legal void punctuated by saloons. The nearest actual courthouse was 100 miles east, which meant disputes were settled through methods that ranged from negotiation to shooting, with very little middle ground. Into this vacuum rode Bean, a saloon owner with entrepreneurial instincts and a complete disregard for legal formalities like training, appointment, or literacy. He declared himself Justice of the Peace, Law, west of the Pecos. Nobody objected, partly because there was no one to object to, and partly because Bean was armed. He set up court in his saloon, the Jersey Lily, named after the actress Lily Langtry, whom he'd never met, but was enthusiastically obsessed with. Trials were held between the bar and the card tables. Sentences were announced from behind the counter. The jury, when Bean bothered to impanel one, was usually whoever was drinking at the time. The famous corpse trial happened in 1884. A man died falling from a railway bridge, and his body was brought to Bean's establishment, which doubled as the local morgue, because why not? While searching the body for identification, Bean discovered $40 and a concealed pistol. He immediately convened court, tried the deceased for illegal weapons possession, found him guilty despite the defendant's notable failure to mount a defense, and imposed a $40 fine. The money went into Bean's register. The gun went into Bean's personal collection. When questioned about the legality of trying a dead man, Bean reportedly said the law didn't specify that defendants had to be alive. So he was working within the spirit, if not the letter of justice. This was typical Bean logic, creative and utterly shameless. His other rulings followed similar patterns. He once freed a man who'd killed a Chinese railway worker, arguing that his law book, which he definitely couldn't read, said nothing about it being illegal to kill a Chinaman. He fined a lawyer $5 for using profane language because the lawyer had cited Latin legal terms Bean didn't understand. He held an inquest on a dead man and ruled the cause of death was stopping a .45 caliber bullet with his chest. Then fined the corpse for creating a public nuisance. Fines were Bean's primary revenue stream. He kept everything collected, treating the court as an extension of his saloon business. Disputes over cards, $5 fine each, property arguments, $10, murder, depended on who had money. If you couldn't pay, Bean accepted livestock, which he'd sell, or labor, which meant working in his saloon. The entire system was designed to funnel resources toward Bean while maintaining enough of justice's aesthetic that people couldn't quite claim he was just robbing them. He maintained this arrangement for 20 years, protected by geography and the complicit understanding that frontier justice was whatever kept the peace. Texas Rangers knew about Bean. County officials knew. Everyone knew. But Bean was predictable, relatively nonviolent compared to actual outlaws, and filling a vacuum that nobody else wanted to fill, at least not while traveling 100 miles to do it. Bean died in 1903, having presided over an estimated 4,000 trials. No records exist for most of them. He likely destroyed them, or used them as kindling, or never made them in the first place because record-keeping implied accountability, and Bean's entire judicial philosophy was built on its absence. The law west of the Pecos died with him. The people he'd convicted and robbed got no appeals, but Bean's frontier farce was at least entertaining. Far more sinister was what happened when corruption moved to criminal courts in major cities, where prosecutors and defense attorneys colluded to guarantee convictions for a price. In 1910, Los Angeles, They called it the system. Everyone knew. No one stopped it. 8. The Los Angeles system. In early 20th century Los Angeles, justice wasn't blind. It had excellent bookkeeping. Every case had a price, every verdict had a buyer, and everyone in the courthouse got a cut. They called it the system, and it ran like a well-oiled machine for 25 years. The beauty of the system was its simplicity. A defendant would be arrested, usually for something they'd actually done, which made the initial paperwork legitimate. Within days, a defense attorney would approach the family. Not someone they'd hired, someone who'd found them. The attorney would explain the situation with practiced concern. The charges were serious. The evidence was strong. But there were options. For a fee, a substantial fee, he could guarantee an outcome. Not hope for, not work toward. Guarantee. The family, desperate and unfamiliar with legal process, would pay. Sometimes in cash, sometimes in property, sometimes in promissory notes that would haunt them for years. The attorney would pocket a percentage, pass the rest up the chain to the prosecutor, who would receive instructions on which case needed particular attention, to the judge, who would receive notification that courtroom schedule should accommodate certain flexibility. The prosecutor would then deliberately botch the case. Not obviously. The system valued subtlety. Key evidence would be misfiled, arriving at trial incomplete. Witnesses would be scheduled poorly, their testimony rushed or interrupted. Chain of custody documentation would contain small errors, just enough to create reasonable doubt. The prosecution would seem earnest, committed, but somehow perpetually undermined by unfortunate circumstances. The judge would rule in ways that advantaged the defense. Objections sustained, evidence excluded, jury instructions worded to encourage acquittal. All within the bounds of judicial discretion, all defensible as legal interpretation, none of it quite provable as corruption. The defendant would walk free. The family would be grateful, convinced they'd purchased excellent legal representation rather than predetermined outcome. And the system would move to the next case. This wasn't occasional. This was industrial. Court records from 1910 to 1935 show patterns that would make statisticians weep. Defense attorneys with impossibly high success rates, prosecutors with conviction rates that varied wildly depending on which judge presided, judges whose rulings aligned perfectly with which attorneys appeared before them. The data screamed corruption, but data doesn't testify, and everyone who could testify was being paid. The financial structure was sophisticated. Monthly stipends distributed from a central fund, managed by senior defense attorneys who'd built the system in the first place. Payments disguised as legal fees, consulting charges, expert witness compensation. Money laundered through legitimate practices, taxed as legitimate income, indistinguishable from honest legal work except for the guaranteed outcomes. Cases ranged from petty theft to murder. The fee scaled with severity. A burglary charge might cost a few $100s. Manslaughter, several thousand. Murder, tens of thousands. But all could be fixed. All would be fixed, assuming payment cleared. The system didn't discriminate based on guilt or innocence, only liquidity. It finally collapsed in 1935, not because someone developed a conscience, but because journalist Clifford Clinton started asking expensive questions. He'd been investigating municipal corruption, following money through city contracts, when he noticed the patterns in court records. He published. The city ignored him. He published more. The city tried to shut down his restaurant on false health violations. He published even more, now including documentation of the system's structure, names, payments, cases. The grand jury, finally forced to act by public pressure, heard testimony from lower-level participants who'd been promised immunity. Court clerks described the payment structure. Bailiffs confirmed the scheduling manipulations. Junior prosecutors admitted they'd been trained in how to lose cases without appearing to try. The evidence was overwhelming, meticulous, and largely useless. 3 judges were removed from the bench. 2 prosecutors resigned. A handful of defense attorneys were disbarred, though most were reinstated within years. But the defense attorneys who'd built the system? They kept practicing. They moved to different courts, different jurisdictions, same methods. The cases they'd thrown? Never reviewed? Too many? Too expensive? Too embarrassing. Los Angeles moved on. The system just changed its name. But Los Angeles wasn't even America's most corrupt legal city. That title belonged to Chicago. And in 1921, one trial there would showcase corruption so brazen that even the Chicago Tribune called it a travesty wrapped in a farce. They called it the Black Sox trial. If you're still with us after 7 cases and a couple centuries of corruption, you're exactly the kind of curious mind we make these for. Hit subscribe so you don't miss the rest of the rabbit hole, and tell us in the comments, where in the world are you watching from and what time is it? Are you watching this with insomnia or morning coffee? Either way, we're just getting started. 9. The Black Sox trial judge. 8 baseball players through the World Series. Everyone knew it. The jury knew it. The judge knew it, because he'd been paid to make sure they walked free. The 1919 World Series was fixed before the first pitch. The Chicago White Sox, heavily favored, lost to the Cincinnati Reds in what sports writers immediately recognized as suspicious baseball. Players making errors that professional athletes shouldn't make. Pitches thrown to locations that helped opposing batters. A collective performance so deliberately mediocre, it read like parody. The conspiracy unraveled slowly, publicly through 1920. Journalists investigated. Players confessed. Grand juries convened. By 1921, 8 White Sox players were indicted for conspiracy to commit fraud, and the trial became national spectacle. America wanted justice for its betrayed pastime. What it got was Judge Hugo Friend. Friend had been appointed to the Illinois Circuit Court through connections that were never fully transparent, but reportedly involved substantial gambling interests. Chicago in 1921 operated on patronage, and Friend's patron was a man named Arnold Rothstein, who happened to be the gambler who'd allegedly orchestrated the World Series fix in the first place. This conflict of interest was noted in newspapers and ignored by everyone with authority to do something about it. The trial was theater. Prosecutors presented evidence that would have convicted in any functional courtroom. Player confessions, though mysteriously gone missing from official files and mysteriously reappearing as unsigned copies. Gambling records showing massive bets placed by associates of the players. Testimony from other players about suspicious conversations. The conspiracy was documented, detailed, and apparently insufficient. Friend steered the proceedings with the subtlety of someone who didn't particularly care if people noticed. He ruled prosecution evidence inadmissible on technicalities so minor that legal scholars still debate what those technicalities actually were. He instructed the jury that conspiracy required proof of harm to specific individuals, not to the abstract concept of baseball's integrity, which was like saying murder requires proof that someone would have contributed meaningfully to society. The confessions, those mysteriously missing then reappearing documents, were ruled inadmissible because they weren't properly authenticated. By whom Friend didn't specify? Using what process he didn't clarify. The jury receiving instructions that essentially required them to ignore most of the evidence, deliberated for less than 3 hours. Not guilty. All 8 players acquitted. The courtroom erupted in applause from the gambling interests who'd packed the gallery. The players celebrated. Friend collected his fee through methods that were never recorded, but can be reasonably inferred from his sudden financial improvement in the months following the trial. He purchased property in Lake Forest, upgraded his chambers, and reportedly hosted Arnold Rothstein at his home for dinner. Baseball responded by banning all 8 players for life anyway, because the sports commissioner understood that legal acquittal didn't mean actual innocence, just successful corruption. The players spent the rest of their lives maintaining they'd been wrongly accused, which was technically correct if you accepted that throwing a World Series wasn't actually criminal, just ethically catastrophic. Friend continued presiding until 1929, his reputation intact within the legal community that valued discretion over ethics. The verdict stood. The fix was complete, and Chicago's courtrooms remained as they'd always been, available for the right price. The Black Sox weren't even Chicago's most corrupt sporting scandal. That came decades later, when corruption moved from gambling to civil rights, from fixing baseball games to fixing justice itself. In 1931, Alabama, 9 boys would face something worse than a corrupt judge. They'd face an entire system determined to convict. Enter the Scottsboro Boys. 10. The Scottsboro Boys Trials. They were children. 9 boys, ages 13 to 20, accused of a crime that never happened. The trials that followed weren't just corrupt. They were ceremonial lynchings with gavels instead of ropes. It began on a freight train in Alabama, March 1931. The Great Depression had turned train hopping into standard practice for anyone desperate enough to travel without money, which was most people. A group of white teenagers and a group of black teenagers ended up on the same train. A fight broke out. The black teenagers won. The white teenagers, humiliated, reported them to authorities in the next town. By the time the train stopped in Paint Rock, Alabama, the story had evolved. Now there were 2 white women on the train, Ruby Bates and Victoria Price. Now there had been a rape. Multiple rapes. 9 suspects were immediately arrested. Their ages ranged from 13 to 20. Several couldn't read. None had attorneys. All were black, which in 1931 Alabama meant they were guilty before evidence was even fabricated. The trials began 12 days later. 12 days from arrest to trial for capital rape charges. The defense attorney was a local real estate lawyer who'd been appointed that morning, had never tried a criminal case, and reportedly showed up drunk. He called no witnesses, presented no evidence, and barely cross-examined the accusers, whose stories contradicted each other in ways that should have created reasonable doubt, but instead created nothing. The jury was all white. Alabama law technically allowed black jurors, but jury rolls were compiled from voter registration lists, and black citizens mysteriously never appeared on those lists. The pattern was systematic, documented, and legally sanctioned. The trials would be segregated, the juries would be white, and the verdict would be predetermined. Judge Alfred Hawkins presided over the first trials with the demeanor of someone conducting a formality. He allowed the prosecution to present medical evidence that contradicted the accuser's timeline. He allowed testimony that one of the women was a known prostitute, which in 1931 should have damaged her credibility, but somehow only made the jury angrier that a white woman, regardless of occupation, had been violated by black teenagers. The defense tried to argue the obvious. The women's stories didn't match. The medical evidence showed no sign of rape. Several of the defendants had never even been in the same train car. Hawkins ruled these arguments irrelevant. The crime itself was proven by the accuser's testimony. Their inconsistencies were trauma, not lies. The jury deliberated less than 2 hours for the first trial. Guilty. Death penalty. 8 more trials followed the same pattern. Different judges, same outcome. The only defendant to avoid execution was 13-year-old Roy Wright, whose jury deadlocked not on innocence, but on whether executing a child was excessive. Even in 1931 Alabama, some jurors had limits. Barely. Appeals began immediately, not because Alabama's legal system cared about justice, but because national attention forced scrutiny. The International Labor Defense took up the case, bringing better attorneys, expert witnesses, and uncomfortable questions about Southern jurisprudence. The appeals reached the Supreme Court twice. Both times, the court ruled the trials had violated constitutional rights, once for inadequate counsel, once for systematic jury exclusion. Alabama retried them anyway. New trials, new judges, same juries, same verdicts. Judge William Callahan presided over the retrials in 1933 with open contempt for the defense. He refused to allow testimony about Victoria Price's past. He instructed the jury that the state's burden of proof was merely reasonable evidence, not beyond reasonable doubt. He suggested that Alabama's honor was on trial, not the defendant's. One of the accusers, Ruby Bates, recanted. She admitted the rape never happened, that Victoria Price had convinced her to lie to avoid vagrancy charges. She testified for the defense, describing the fabrication in detail. The jury convicted anyway. The trials stretched across 6 years, multiple retrials, countless appeals. Charges were eventually dropped for 4 defendants when prosecutors quietly admitted they had no evidence. The others were convicted, sentenced to long prison terms, and slowly released over the following decades. The last, Andy Wright, was paroled in 1950, 19 years after his arrest. Judge Hawkins retired in 1935, his reputation intact. Judge Callahan continued presiding until 1963. Both were praised by Alabama bar associations for their service. Neither faced consequences for presiding over trials that became international symbols of judicial corruption wrapped in racial terror. The Scottsboro boys weren't guilty. They weren't even on trial, not really. Their guilt or innocence was beside the point. The point was showing what happened when black teenagers fought white teenagers in Alabama. The point was maintaining order, and the courts, with their robes and procedures and formalities, made that terrorism legal. Which brings us to a different kind of corruption, one that happened not in southern courtrooms, but in northern chambers, where one federal judge turned his position into a profit center so successfully that he influenced corporate law for 15 years before anyone caught him. His name was Martin Manton. 11. Judge Martin Manton. For 15 years, Martin Manton was the second most powerful judge in America. For all 15 of those years, he was for sale. Manton sat on the United States Court of Appeals for the Second Circuit, which covered New York, Connecticut, and Vermont. In the federal court system, appeals courts are where corporate law lives and dies. District courts handle trials, but appeals courts set precedent, interpret regulations, and decide which corporations win billion-dollar disputes. Manton understood this. He understood it very well, and he built a business model around it. His method was elegant. Attorneys would approach him, usually through intermediaries, usually during the period between oral arguments and written decision. They'd explain their client's position. They'd emphasize the economic impact of an unfavorable ruling. They'd suggest that perhaps the judge's personal financial situation might benefit from certain investments, loans, or business opportunities. Manton would listen. Then he'd rule. The bribes weren't cash in envelopes. They were corporate stock, purchased through shell companies, loans that were never repaid, listed as business ventures. Consulting fees for advice he never gave to companies whose cases he was actively deciding. Partnership stakes in businesses owned by litigants appearing before him. The corruption was laundered through legitimate-looking transactions, documented by accountants, reported as income, taxed accordingly. Everything legal except the part where he was selling verdicts. Corporate bankruptcy cases were particularly lucrative. Companies facing reorganization had everything to lose, which meant everything to offer. Manton developed a reputation among certain attorneys as someone who could be reasoned with on bankruptcy matters. His rulings in these cases showed remarkable consistency. They favored whoever had most recently improved his financial portfolio. One case involved American Tobacco Company facing antitrust violations. Manton received $250,000 in loans and stock from parties connected to the company. He ruled in their favor. Another case involved a patent dispute worth millions. Manton received $100,000 in various financial arrangements. He ruled for the party that had paid. The pattern repeated across insurance disputes, corporate liability cases, securities fraud, contract law. Every ruling came with a receipt. If you knew where to look. He was careful. Payments were timed to avoid obvious correlation with specific rulings. Shell companies created layers between money and judge. Intermediaries insulated him from direct contact with litigants. For over a decade, the system worked. Manton grew wealthy, accumulated properties, lived far beyond a federal judge's salary, and explained it as savvy investing. The unraveling started in 1939 when a disgruntled attorney, facing disbarment for unrelated corruption, decided to take someone down with him. He provided federal investigators with documentation of payments, shell company structures, and correspondence that connected Manton to litigants. The evidence was meticulous, damning, and previously invisible because no one had bothered to look. Manton was indicted, tried, and convicted of conspiracy to obstruct justice and defraud the United States. He resigned from the bench, was sentenced to 2 years in federal prison, and served 19 months. Upon release, he returned to private life, disgraced, but not destitute. The properties remained his. The wealth accumulated through 15 years of judicial corruption was never fully recovered by the government. His conviction sent shockwaves through the federal judiciary, but primarily because he'd been caught. The methods he'd used, shell companies, intermediary payments, financial arrangements disguised as legitimate business, these weren't revolutionary. They were just usually better hidden. Manton's real crime, from the perspective of the system, wasn't corruption. It was sloppiness. Judicial corruption would continue, just more carefully. But sometimes corruption operates on a scale so vast that careful or sloppy becomes irrelevant. Sometimes the entire legal system transforms into an instrument of atrocity. And in 1947, the world put that transformation on trial. Not the atrocities themselves. Those trials were famous. But the judges who'd made atrocities legal. Enter the Nuremberg judges' trial. 12. The Nuremberg judges. They never killed anyone. They just made it legal. 16 German judges stood trial at Nuremberg for corrupting justice itself. Their defense? They were only following the law they'd written. The main Nuremberg trials, the famous ones, prosecuted Nazi military and political leaders for crimes against humanity. Those trials made headlines, shaped international law, and created the template for holding state actors accountable. But in 1947, the Allies conducted a second series of trials, lesser known, focused on the infrastructure that had enabled atrocity. Doctors who'd conducted medical experiments, industrialists who'd profited from slave labor, and judges who'd transformed German courts into extermination machinery. The defendants were distinguished, educated men. Several held doctorates in law. All had presided over German courts during the Nazi regime, and all had interpreted law in ways that made genocide procedurally correct. They hadn't ordered mass killings. They'd ruled that mass killings were legal. The distinction, they insisted, was everything. The prosecution presented case after case, showing how these judges had twisted law to serve ideology. Racial purity laws that stripped citizenship from Jews, making them non-persons under law. Sterilization orders issued against undesirables based on pseudo-scientific racial categories. Death sentences for trivial offenses when the defendant was Polish, Jewish, or politically suspect. Each ruling was documented, filed, stamped with judicial authority. One judge, Oswald Rothaug, had specialized in death sentences. His courtroom in Nuremberg became known as a murder factory, processing political prisoners through trials that lasted hours before sentencing them to execution. He'd sentence people to death for listening to foreign radio broadcasts, for making jokes about Hitler, for being insufficiently enthusiastic about the war effort. Each sentence was legal, properly documented, following the letter of laws that Rothaug and his colleagues had helped draft. Another, Franz Schlegelberger, had served as State Secretary of Justice, the second highest position in Germany's judicial system. He'd signed orders implementing racial laws, authorizing concentration camp detention without trial, and expanding death penalty eligibility to include ever broader categories of defendants. His signature appeared on documents that made the Holocaust administratively feasible. He argued he was a civil servant, following orders, operating within legal frameworks. The defense was consistent across all 16 defendants. They'd been judges. Judges interpret law. The laws they'd interpreted were passed by legitimate government, the Nazi regime having come to power through legal means initially. Their role was to apply law, not question it. To do otherwise would have violated judicial neutrality. The prosecution argued something more fundamental. That law itself has limits. That judicial authority carries moral responsibility. That no legal system can make atrocity legitimate just by calling it legal. That the judge's corruption wasn't in taking bribes or fixing verdicts, but in using legal machinery to industrialize murder while maintaining the fiction of justice. The trial revealed thousands of cases these judges had decided, each one documented with the precision German bureaucracy demanded. Jews stripped of property through legal proceedings, Poles executed for crimes that wouldn't have warranted punishment if committed by Germans. Political dissidents sentenced to death for speech that, under any reasonable interpretation, constituted protected expression. But under Nazi law, as interpreted by these judges, all of it was legitimate. The evidence included courtroom transcripts showing judges openly expressing racial ideology from the bench, sentencing documents where judges cited racial inferiority as justification, legal memoranda these judges had written, advising on how to expand death penalty statutes to cover more categories of victims. They hadn't been corrupted by the regime. They'd been instrumental in building it. 10 judges were convicted. 4 were acquitted, their specific actions deemed insufficiently criminal or too difficult to prove beyond reasonable doubt. The sentences ranged from 5 years to life imprisonment. Most served a fraction of their terms before being released during the 1950s as Cold War politics made former Nazis useful again. The trial asked questions that remain unanswered. What is justice when the law itself is corrupted? What is judicial independence when independence enables atrocity? What do you do with judges who followed every procedure correctly while facilitating genocide? The Nuremberg judges' trial proved that corruption doesn't require bribes. Sometimes it just requires judges willing to trade humanity for order, willing to follow laws that shouldn't exist, willing to call it justice because they wrote the rules. That's not corruption in the traditional sense. That's civilization eating itself through its own institutions. But corruption in America had its own complications. Sometimes the system didn't enable injustice through evil judges. Sometimes it punished good ones. In 1940s South Carolina, one judge discovered that ruling fairly in civil rights cases could be more dangerous than taking bribes. His name was J. Waddies Waring. 12 cases down, 18 to go. We've moved from individual corruption to systematic evil. If you need a break, we understand. But if you're still here, hit subscribe. These stories need witnesses. Comment below. What's the line between bad judgment and corrupt judgment? We're about to blur it even further. 13. Judge J. Waddies Waring. Most of these stories are about corrupt judges getting away with it. This one's different. This is about an honest judge getting punished for it. J. Waddies Waring was everything Charleston, South Carolina wanted in a federal judge. Born into old Southern aristocracy, raised on Confederate nostalgia, married into more old money, appointed to the bench in 1942 with unanimous approval from everyone who mattered. He was expected to uphold tradition, which in 1940s South Carolina meant upholding segregation, disenfranchisement, and the entire apparatus of Jim Crow. For his first few years, he did exactly that. His rulings were predictable, deferential to state authority, unmistakably Southern. Then something shifted. Maybe it was his second marriage to a Northerner who questioned assumptions he'd never questioned. Maybe it was the cognitive dissonance of presiding over a court that claimed to dispense justice while systematically denying it to black citizens. Whatever the cause, Waring started ruling based on law rather than tradition. In 1947, he ruled that South Carolina's all-white Democratic primary was unconstitutional. The state had argued that political parties were private, organizations that could exclude anyone they wanted. Waring noted that in a one-party state, the primary was the election, and excluding black voters from the primary was denying them the vote. His ruling desegregated South Carolina's elections. The response was immediate. Death threats arrived daily. His Charleston home was vandalized. Crosses were burned on his lawn. Fellow judges stopped speaking to him. His own family disowned him. Charleston society, which had embraced him his entire life, now treated him as a traitor to his race and class. He kept ruling. In 1950, he issued an opinion in Briggs v. Elliott, one of the cases that would eventually become Brown v.'s Board of Education. He wrote that segregation in public schools was unconstitutional, that separate was inherently unequal, and that South Carolina's educational system violated the 14th Amendment. His opinion was 2 years ahead of the Supreme Court's eventual ruling in Brown. It was also 2 years ahead of what his judicial colleagues were willing to accept. The other judges on the panel outvoted him. His opinion became a dissent, but it laid groundwork for the Supreme Court's eventual reasoning. Thurgood Marshall later credited Waring's dissent as crucial to the legal strategy that won Brown v. Board. Charleston responded by making Waring's life impossible. Restaurants refused to serve him. Stores declined his business. His church asked him to leave. Police offered no protection when threats escalated. The local bar association began investigating him for ethics violations, the charge being that he'd ruled based on his personal beliefs rather than law, which was rich considering every other Southern judge was doing exactly that to maintain segregation. Federal marshals eventually had to provide security. Waring's home required guards. After someone fired shots through the windows, he and his wife began spending more time in New York, where federal judges who ruled on civil rights weren't treated as enemy combatants. He retired in 1952 and moved to New York permanently. Charleston celebrated his departure. South Carolina's legal establishment treated his tenure as an aberration, a temporary madness that thankfully ended. His rulings, the ones that had desegregated primaries and challenged school segregation, stood as law. But the man who'd issued them was erased from South Carolina's institutional memory. Waring's story inverts the usual narrative. Corruption isn't always about judges taking bribes. Sometimes it's about a system so thoroughly corrupted that honesty becomes the crime. Charleston didn't need to pay judges to maintain white supremacy. It just needed judges who understood that certain rulings would destroy their lives. Waring chose to rule honestly anyway. The system ensured he paid for it. While Waring fought corruption through judicial honesty, thousands of miles away in Quebec, judges were enabling systematic abuse on a scale that wouldn't be fully understood for decades. They weren't brave or honest. They were complicit, and their signatures created 20,000 victims. They called them the Duplessis Orphans. 14. The Duplessis Orphans. 20,000 children, falsely diagnosed, institutionalized, abused, all signed off by judges who knew exactly what they were doing. They called them the Duplessis Orphans. The judges called them revenue streams. Quebec in the 1940s operated under a political machine controlled by Premier Maurice Duplessis and the Catholic Church. The two institutions functioned as a single organism, each legitimizing the other, both profiting from an arrangement that turned vulnerable children into a financial commodity. The mechanism was elegant, bureaucratic, and sustained by judicial signatures. Here's how it worked. The federal government provided funding to provinces for psychiatric institutions at a higher rate than for orphanages. Psychiatric patients cost more to house treat, and manage, so federal subsidies reflected that difference. Orphanages received modest per-child payments. Psychiatric hospitals received substantial per-patient funding. The gap was significant enough to reshape an entire childcare system around fraud. Quebec had thousands of orphans, children born out of wedlock, surrendered by unwed mothers who faced social ostracism, placed in church-run orphanages that operated on threadbare budgets. Duplessis and church officials recognized an opportunity. If these children could be reclassified as mentally ill, the institutions housing them would receive substantially more federal money. All they needed was medical diagnosis and judicial approval. The diagnoses came first. Doctors, many employed by the church or politically connected to Duplessis, examined children in orphanages and discovered epidemic levels of mental illness. Children who were perfectly healthy became schizophrenic on paper. Children with minor behavioral issues became criminally insane. The diagnostic standards were flexible, creative, and entirely focused on maximizing the number of psychiatric patients. Then came the judges. Quebec's judicial system included specialized courts that handled psychiatric commitments. Judges in these courts reviewed medical diagnoses and issued orders committing individuals to psychiatric institutions. The process was supposed to protect vulnerable people from wrongful institutionalization. Instead, it rubber-stamped fraud on an industrial scale. Judges received batches of commitment orders, dozens at a time. Children they'd never met, diagnosed with conditions based on cursory examinations. The paperwork was perfunctory. Medical recommendation, judicial signature, commitment finalized. Processing time per child, minutes. The judges knew what they were signing. They had to know. The volume alone should have raised questions. The ages of the patients, many under 10 years old, should have raised questions. The fact that orphanages were converted into psychiatric hospitals overnight should have raised questions. They signed anyway. Month after month, year after year, from the late 1940s through the 1960s, thousands of children committed to institutions where they would spend years, sometimes decades, receiving treatment for illnesses they didn't have. The children suffered conditions that defy clinical description: overcrowded wards, minimal food, physical abuse disguised as behavioral correction, sexual abuse, protected by institutional waltash. Many were forced to work, unpaid labor presented as therapy. Some were used in medical experiments. Others simply warehoused decades of life spent in institutions because judges had signed papers converting them from orphans into psychiatric patients. The financial arrangement enriched both church and state. The Catholic Church operated most of the institutions, receiving federal payments for each patient. Duplessis's government received political capital from the church and federal funding that could be redirected to other provincial priorities. The system worked beautifully for everyone except the children, who had no voice, no advocates, and no legal recourse, because judges had declared them mentally incompetent. Exposure came slowly, beginning in the 1990s when survivors started organizing, comparing experiences, and recognizing patterns. They'd been orphans, healthy children, who'd been systematically reclassified as psychiatric patients to generate revenue. Documentation emerged showing the scope: approximately 20,000 children over 2 decades. Institutions that had been orphanages 1 year, psychiatric hospitals the next, with the same children suddenly diagnosed with severe mental illness. The judicial signatures were still on file. Thousands of commitment orders, dated signed by judges whose names were recorded. The judges themselves were long dead or retired, but the evidence of their complicity remained archived in Quebec's court records, each signature a small act of corruption that accumulated into systematic abuse. Quebec eventually issued apologies. Financial compensation was debated, delayed, and delivered inadequately. Many survivors received small settlements that couldn't possibly compensate for stolen childhoods. for the stigma of false psychiatric diagnoses that followed them through life, for the abuse endured because judges couldn't be bothered to question suspicious paperwork. The Duplessis orphans revealed something about judicial corruption that transcends individual bribery. Sometimes corruption is administrative, banal, a matter of signing forms and processing paperwork without caring about consequences. The judges weren't monsters, they were bureaucrats, and their bureaucratic indifference destroyed 20,000 lives. But bureaucratic corruption could be challenged, at least theoretically, through oversight and reform. What happened when corruption was personal, targeted, and protected by raw power? In 1960s Oklahoma, one federal judge found out exactly how far mob connections could protect judicial misconduct. His name was Stephen S. Chandler, 15. Judge Stephen S. Chandler. Some judges take bribes from the mob. Stephen Chandler was on the mob's payroll. Chandler was appointed to the federal bench in Oklahoma's Western District in 1961, a position that came with lifetime tenure and jurisdiction over cases involving federal crimes, including racketeering, drug trafficking, and organized crime. For someone with existing mob connections, it was an ideal placement. For the mob, it was an investment that paid dividends for years. The connections weren't secret, not exactly. Chandler had represented organized crime figures as a private attorney before his appointment, which wasn't disqualifying, but should have raised flags. His social circle included known mob associates. His financial records, when eventually examined, showed loans from sources with questionable legitimacy. But in 1960s, Oklahoma, where oil money mixed freely with less legitimate enterprises, these associations were noted and ignored. His rulings showed patterns. Cases involving defendants with mob connections moved through his courtroom with unusual speed when outcomes favored the defense, unusual delay when they didn't. Evidence that should have been admitted was excluded on technicalities. Witnesses who could damage mob interests were deemed unreliable. Sentencing for convicted mobsters in Chandler's court was remarkably lenient compared to national averages. Federal prosecutors noticed. They began documenting irregularities, building case files on cases where Chandler's rulings seemed less about law and more about outcome engineering. But investigating a sitting federal judge required approval from the Department of Justice, political will from local officials, and courage from prosecutors who'd have to continue practicing before Chandler while investigating him. The investigation finally happened in 1977, over a decade after concerns first emerged. Chandler was charged with judicial misconduct based on documented connections to organized crime figures, financial irregularities, and a pattern of rulings that consistently favored mob interests. The charges were serious, but difficult to prove beyond reasonable doubt. Mob connections aren't illegal. Biased rulings aren't criminal unless you can prove corrupt intent. And Chandler had spent years insulating himself through layers of intermediaries and plausible deniability. He avoided criminal conviction, but faced impeachment proceedings in Congress. The evidence, while insufficient for criminal prosecution, was overwhelming for removal. Chandler resigned in 1979 before the impeachment vote, maintaining his innocence but accepting retirement rather than face public trial. His cases were never systematically reviewed. Hundreds of rulings, spanning nearly 2 decades, many involving organized crime, all potentially tainted by corruption. But reviewing would mean acknowledging that a federal judge had been compromised for years while the system looked away. Chandler's corruption thrived because federal judges are nearly untouchable. Lifetime appointments, high barriers to removal, minimal oversight. The system assumes judges will police themselves through ethical behavior. When they don't, and when their corruption serves powerful interests, the machinery for accountability moves slowly if it moves at all. Oklahoma learned this lesson. So did Maryland, where in the late 1970s, a governor and multiple judges created a pardon-selling scheme so brazen it made Chandler look subtle. Sentence them harsh, pardon them expensive. That was the business model. And for 3 years in Maryland, it was also state policy. 16. The Marvin Mandel Pardon Scandal. The system was simple. Maryland judges would impose maximum sentences on defendants who could afford to pay. Then Governor Marvin Mandel would sell them pardons. Everyone got a cut. Everyone except the families who mortgaged homes to buy their relatives' freedom from sentences that should never have been imposed. Mandel was elected Maryland's governor in 1969, replacing Spiro Agnew, who'd moved up to vice president. He came from the state legislature, where he'd spent decades mastering Maryland's particular brand of political machinery, patronage, favors, and the understanding that government positions existed primarily to generate income for those holding them. As governor, he simply scaled up. The pardon scheme required cooperation. Judges had to be willing to impose harsh sentences on defendants whose families had resources. Defense attorneys had to identify which clients could pay. And intermediaries, usually politically connected lawyers, had to facilitate the transactions without creating obvious paper trails. Maryland's court system, particularly in Baltimore, had all three elements in place. Judges would sentence defendants to terms far exceeding sentencing guidelines. A theft that typically warranted probation became 5 years. Drug possession became a decade. The harsh sentences served dual purposes. They demonstrated toughness on crime for the judge's reputation, and they created desperate families willing to pay anything for reduction. Defense attorneys would approach these families with discreet suggestions. The governor's office sometimes granted pardons or commutations for humanitarian reasons. Perhaps a contribution to the governor's preferred causes might demonstrate the family's civic commitment. The amounts varied, typically ranging from $10,000 to $50,000, depending on the sentence and the family's apparent wealth. Payment was structured to avoid obvious bribery charges. Cash rarely changed hands directly. Instead, families would make donations to political campaigns, invest in businesses owned by Mandel's associates, or purchase real estate at inflated prices from sellers connected to the governor's circle. The money moved through enough intermediaries that tracing direct corruption required forensic accounting and patient investigators. The pardons would follow months later. Mandel would announce commutations, citing factors like overcrowding in prisons, good behavior, or family circumstances. The timing created plausible deniability. Payment in March, pardon in September. The gap made connecting them difficult, at least officially. The scheme operated from 1970 to 1977, processing dozens of pardons and commutations that followed the same pattern. Harsh sentence, wealthy family, payment disguised as legitimate transaction, eventual pardon. Federal investigators eventually noticed through wiretaps conducted for unrelated corruption cases. Conversations between intermediaries discussed arrangements and consideration in ways that suggested something beyond legitimate legal fees. Mandel was indicted in 1977 for mail fraud and racketeering related to the pardon scheme and separate corruption involving racetrack interests. He was convicted in 1977, sentenced to 4 years, and served 19 months before his sentence was commuted by President Reagan in 1981. Several judges were investigated, but none were criminally charged, proving that judges had intentionally imposed harsh sentences specifically to enable the pardon scheme required demonstrating intent that couldn't be established beyond reasonable doubt. The judges claimed they'd simply been following sentencing law, which gave them broad discretion. The families who'd paid never recovered their money. The sentences that had been commuted stayed commuted, but the financial destruction of paying ransom for justice left many bankrupt. And Maryland's legal system continued operating with many of the same judges, same attorneys, same structural vulnerabilities that had enabled the scheme. Federal judges, of course, couldn't be touched by state corruption investigations, but sometimes federal judges brought their own scandals. In the 1980s, one federal judge orchestrated racketeering case dismissal for $150,000. He was caught, he was impeached, he was removed from the bench. Then Florida elected him to Congress, where he served for 30 years. His name was Alcee Hastings, 17. Judge Alcee Hastings. Alcee Hastings accepted a $150,000 bribe to throw a case. He was caught, he was impeached, he was removed from the bench. Then Florida elected him to Congress, where he served for 30 years. Hastings was appointed to the federal bench in Florida's Southern District in 1979, one of the first black federal judges in the South. His appointment was celebrated as progress, a sign that the federal judiciary was finally reflecting the population it served. What it actually reflected was that corruption doesn't discriminate by race, only by opportunity. The case that ended his judicial career began in 1981 with defendants Frank and Thomas Romano, brothers facing racketeering charges related to a stolen car operation. They needed the case dismissed. Their attorney, William Borders, knew a judge who could arrange it. For $150,000, split between Borders and Hastings, the racketeering charges would disappear. The arrangement was discussed over multiple phone calls, in restaurants, and through intermediaries. What none of them knew was that the FBI had been investigating Borders for unrelated corruption and had wiretapped his phone. The conversations about the Romano case were recorded, detailed, and damning. Hastings and Borders discussed payment methods, timing for the dismissal, and how to structure the ruling to avoid suspicion. Hastings dismissed the charges in February 1982. His written ruling cited lack of evidence, prosecutorial overreach, and constitutional concerns about the search that had led to charges. The reasoning was professionally written, legally plausible, and completely fabricated. The real reason was $150,000, half of which Borders collected and attempted to deliver to Hastings through a series of cash payments disguised as loans and business investments. The FBI arrested Borders in 1983. The evidence was overwhelming. Recorded conversations, documented payments, bank records showing money flowing from the Romanos through Borders toward accounts controlled by Hastings. Borders was convicted of conspiracy to bribe a federal judge and sentenced to 5 years. Hastings was indicted in 1983 on bribery and conspiracy charges. His trial in 1983 resulted in acquittal, though not because the jury believed he was innocent. The jury couldn't definitively prove that Hastings had received the money, only that Borders had attempted to deliver it. The distinction was technical, frustrating, and apparently sufficient for acquittal. But federal judges aren't only accountable to criminal courts, they're also accountable to Congress through impeachment. The House of Representatives investigated, examining the same evidence the jury had seen, plus additional documentation of Hastings' financial records showing unexplained income around the time of the Romano dismissal. The House impeached him in 1988. The Senate tried him in 1989, only the 6th federal judge impeached and removed in American history. The vote was 69 to 26 for conviction on conspiracy charges. Hastings was removed from the bench, his judicial career ended, his reputation destroyed. Then something remarkable happened. Florida's 23rd Congressional District elected him to the House of Representatives in 1992. He ran openly as a former judge who'd been wrongly persecuted by a politically motivated impeachment. His district, predominantly black and Democratic, saw his removal as racially targeted rather than corruption justified. He won convincingly. Hastings served in Congress from 1993 until his death in 2021, nearly 3 decades. He became a senior member of the Rules Committee, wielded significant power over House procedure, and was never seriously challenged in his district. His congressional career far outlasted his judicial one. The position he was impeached from led directly to the position he held for 30 years. The irony wasn't lost on legal scholars. Federal judges serve for life, removable only through impeachment. Congress members serve 2-year terms, removable by voters. Hastings was removed from the position with more accountability and elected to the position with less. Democracy, apparently, has a sense of humor. Not all corrupt judges get second acts. Most simply fade into retirement, their corruption quietly archived. But some modern cases broke through the silence spectacularly. In Pennsylvania during the 2000s, 2 judges created a scheme so brazenly mercenary that it shocked even a nation accustomed to judicial corruption. They monetized childhood itself. They called it Kids for Cash, 18, the Kids for Cash conspiracy. 2 judges, 5,000 children, $28 million in kickbacks. This is the story of how the justice system learned to monetize childhood. Luzerne County, Pennsylvania, 2003. The juvenile court system was struggling with outdated facilities and insufficient detention space. 2 judges, Mark Ciavarella and Michael Conahan, saw an opportunity. A private company, PA Child Care, proposed building new juvenile detention facilities. All the county needed to do was guarantee occupancy. The judges were happy to help. The arrangement was elegant. PA Child Care would build 2 facilities, investing millions in construction. In exchange, Ciavarella and Conahan would receive kickbacks tied to the number of children detained. The more kids incarcerated, the more money the judges made. Payment was structured as finder's fees for directing business to the facilities, laundered through shell companies, and reported as consulting income. Ciavarella was the conviction machine. As the presiding juvenile court judge, he handled nearly every juvenile case in Luzerne County. His courtroom became an assembly line, processing children at speeds that made meaningful hearings impossible. Typical hearings lasted 2 to 3 minutes. Some lasted less than 1. Children were rarely informed of their rights. Defense attorneys were discouraged from zealous advocacy. Parents were kept out of the courtroom. The proceedings had all the trappings of justice: a judge, a bench, legal terminology, but none of the substance. The offenses were trivial by any reasonable standard. A 14-year-old created a fake MySpace page mocking her school's assistant principal. Ciavarella sentenced her to 3 months in detention. A 15-year-old was involved in a scuffle with another student at a football game. 6 months. A 16-year-old helped his friend shoplift DVDs from Walmart, didn't take anything himself but was present. 1 year. A 10-year-old took his mother's car for a joyride, crashed it into a telephone pole. Detention. An 11-year-old made fun of her principal. Detention. These weren't hardened criminals. They were children making mistakes that, in functioning juvenile systems, would result in warnings, counseling, community service. But functional systems don't generate $28 million in kickbacks. Ciavarella's system did. The facilities themselves were harsh. Overcrowded, understaffed, designed for profit, not rehabilitation. Children described spending months in cells, minimal education, arbitrary punishments. Some were shackled during transport. Others reported abuse by guards that went uninvestigated because, officially, these children were delinquents who deserved whatever treatment they received. Families had no recourse. When parents questioned sentences, they were told the judge had broad discretion. When attorneys appealed, higher courts deferred to juvenile court expertise. The system protected itself through layers of procedural deference, each layer assuming the one below was functioning properly. None were. The conspiracy unraveled in 2008 when a local attorney, Robert Powell, started noticing patterns. His juvenile clients were receiving detention sentences far exceeding state averages for comparable offenses. He filed complaints with the State Judicial Conduct Board, documenting case after case of disproportionate sentencing. The board ignored him. He went public. The Wilkes-Barre Times-Leader investigated, discovering financial connections between Ciavarella, Conahan, and PA Child Care's owners. The story broke in January 2009. Within days, federal authorities launched an investigation. Within weeks, they'd uncovered the full scope. $28 million in kickbacks, over 5,000 children sentenced, spanning 2003 to 2008. Ciavarella and Conahan were indicted on racketeering charges. Both eventually pled guilty, though Chiavarella later withdrew his plea and went to trial, claiming he'd done nothing wrong, that his sentencing was within legal guidelines, that the payments were legitimate compensation for unrelated consulting work. The jury didn't buy it. He was convicted on multiple counts and sentenced to 28 years in federal prison. Conahan received 17.5 years. The Pennsylvania Supreme Court vacated thousands of juvenile convictions issued by Chiavarella, an unprecedented mass expungement. But expungement doesn't undo trauma. Children who'd spent months or years in detention, who'd been expelled from schools, who'd lost college opportunities, who'd developed PTSD from incarceration, got their records cleared. They didn't get their childhoods back. Families sued. Many received settlements, compensation that couldn't possibly equal what had been taken. PA Child Care filed for bankruptcy. The facilities were eventually closed, sold, converted to other uses. The infrastructure of corruption was dismantled. The damage remained. Kids for Cash became shorthand for judicial corruption in modern America, proof that even in the 21st century, even in ordinary counties, even involving children, the system could be bought. The case was so shocking because it was so recent, so well documented, and so completely preventable. Every safeguard failed. Every oversight body missed it. For 5 years, 2 judges destroyed thousands of lives, and nobody with authority to stop them bothered to look. Mark Chiavarella's individual story, his psychology, his justifications, deserves closer examination. Because understanding how a judge could do this requires understanding how he saw himself, not as corrupt, as powerful. 19. Judge Mark Chiavarella's individual dissent. Mark Chiavarella sent children to jail for things like trespassing in an abandoned building and making fun of a principal on MySpace. When asked why, his answer was simple: because I could. Understanding Chiavarella requires understanding that he never saw himself as corrupt. In his mind, he was a tough judge, maybe the toughest, maintaining order in a county that needed discipline. The money was separate, incidental, compensation for building a better juvenile justice system. That he'd built a system that incarcerated children for profit was, in his internal narrative, coincidental to his judicial philosophy. His courtroom manner reflected this self-image. He was theatrical, domineering, a judge who believed his role was to terrify children into compliance. He'd yell from the bench, berate defendants, lecture parents about their failures. The performance had an audience. The children processed through his courtroom. The families cowed into silence. The attorneys who learned not to object too vigorously. Former court staff described him as believing he was saving these children, that harsh consequences would prevent future criminality. The fact that research showed the opposite, that juvenile incarceration increased recidivism rather than prevented it, didn't concern him. Research was theory. His courtroom was practice. And in his courtroom, he was saving lives one detention sentence at a time. The money, when confronted about it, he explained as consulting fees. PA Child Care had sought his expertise about juvenile justice facility design. He'd provided that expertise. The payments were legitimate compensation. That his consulting coincided exactly with his judicial decisions to fill those facilities was, he insisted, unrelated. The cognitive dissonance required to maintain this position was impressive, pathological, and apparently sustainable for years. His colleagues noticed nothing, or noticed and said nothing. Luzerne County's legal community operated on the principle that judges were autonomous, that questioning their decisions was inappropriate, that Chiavarella's harsh sentences were just his judicial style. The kickbacks were hidden well enough that casual observation wouldn't reveal them. And casual observation was all anyone bothered with. When the investigation became public, Chiavarella's response was defiance. He initially pled guilty, then withdrew the plea, insisting he'd done nothing wrong. At trial, he maintained that his sentencing was appropriate, within guidelines, justified by the offenses and the defendants' backgrounds. The prosecution presented child after child, now teenagers or adults, describing what Chiavarella had done to them. He showed no emotion, no remorse, no recognition that these were lives he'd destroyed. The jury convicted him in 2011. At sentencing, he finally broke. He sobbed, apologized to the victims, claimed he never meant to hurt anyone. The judge sentencing him, noting the irony of the moment, gave him 28 years. Chiavarella is currently serving that sentence in Kentucky, eligible for release in 2035, when he'll be 85. His breakdown seemed calculated, performative, the same theatrical instinct that had served him on the bench now deployed for mercy. Whether his remorse was genuine is unknowable. What's certain is that for 5 years, he'd felt nothing while destroying thousands of lives. Feeling something only when facing consequences himself suggests the remorse was less about victims and more about self-preservation. Chiavarella wasn't an aberration. He was what happens when judicial power meets financial incentive without oversight. His corruption was enabled by a system that assumes judges act in good faith, that trusts robes to sanctify the wearer. Pennsylvania learned that trust is insufficient. The rest of America hasn't. Chicago had learned this lesson decades earlier, when another judge turned murder trials into a marketplace. For $100,000 per acquittal, Judge Thomas Maloney made murder charges disappear. Operation Greylord exposed him, eventually, but Chicago being Chicago eventually took years. 20. The corruption of Judge Thomas J. Maloney. In Chicago, if you had $100,000 and a good lawyer, murder was a parking ticket. Judge Thomas Maloney made sure of it. Chicago's court system in the 1980s operated on a simple principle. Everything was for sale. Judgeships were purchased through political contributions. Case assignments were negotiated through connections. Verdicts were merchandise, priced according to severity. The entire apparatus functioned as a market, and Thomas Maloney was one of its most reliable vendors. Maloney presided over criminal cases in Cook County Circuit Court, handling everything from theft to murder. His reputation among certain defense attorneys was well known. He could be reached. The euphemism covered a straightforward transaction: pay the judge, get an acquittal. The price for murder cases was $100,000, a figure that apparently remained stable throughout the 1980s despite inflation. The transactions followed a pattern. Defense attorneys connected to Chicago's patronage system would approach Maloney before trial, usually through intermediaries. They'd discuss the case, the evidence, the likelihood of conviction. Then they'd discuss the fee. Payment came in cash, delivered in installments, sometimes split between the attorney and judge, sometimes paid entirely to the judge, with the attorney taking a separate fee from the client. Maloney would then engineer an acquittal. Not obviously, he'd spent years learning how to throw cases with judicial discretion. Key prosecution evidence would be excluded on procedural grounds. Witnesses would be discredited through aggressive questioning that exceeded normal judicial neutrality. Jury instructions would be worded to favor reasonable doubt. The prosecution would seem competent. The trial would appear fair, and the defendant would walk free. Operation Greylord, launched by the FBI in 1980, was designed to expose this corruption through undercover agents and wiretaps. Federal agents posed as attorneys, judges, and court personnel, documenting bribes, recording conversations, and building cases that would eventually indict over 90 Cook County judges, attorneys, and officials. Maloney was one of their targets. The investigation took years. Maloney was careful, using intermediaries, avoiding direct conversations about money, structuring payments to look like legitimate legal fees. But careful isn't the same as invisible. Wiretaps caught intermediaries discussing the judge's fee. Undercover agents documented cash payments. Former associates, facing their own charges, provided testimony about Maloney's system. He was indicted in 1991 on charges of racketeering. bribery, and extortion related to fixing murder trials. The trial presented evidence of at least 3 murder cases where Maloney had accepted payment and issued acquittals. Defendants who should have been convicted walked free because Maloney had been paid to ensure it. The jury convicted him in 1993. He was sentenced to nearly 16 years in federal prison and died in 2008, still maintaining he'd been targeted unfairly, that his rulings were legitimate judicial decisions, that Operation Greylord had manufactured evidence. Chicago's response was institutional shrugging. Maloney was one of dozens of corrupt judges exposed by Greylord. The investigation revealed systematic corruption across the entire court system, but the system itself remained largely unchanged. New judges were appointed through the same political mechanisms. Cases continued being assigned through the same connections. The market for justice simply became more cautious about surveillance. Sometimes judicial corruption wasn't about individual judges selling verdicts. Sometimes it came from the top of a state's judicial hierarchy. In 1992, New York's chief judge, the most powerful judicial position in the state, was arrested for blackmailing his ex-lover. The investigation revealed how he'd been assigning cases for years. His name was Sol Wachtler, 21. Judge Sol Wachtler. He was the most powerful judge in New York. Then he became a federal inmate. But the real crime wasn't the blackmail. It was what the investigation revealed about how he'd been assigning cases for years. Sol Wachtler served as chief judge of New York's Ashes Court of Appeals from 1985 to 1992, the highest judicial position in the state. He controlled which cases the court heard, assigned opinions to specific judges, and wielded influence that extended throughout New York's entire legal system. His reputation was sterling, his legal mind respected, his future potentially including a Supreme Court nomination. Then he started sending threatening letters to his ex-lover's daughter. The personal unraveling was spectacular. Wachtler's affair with Joy Silverman, a Republican Party fundraiser, ended badly in 1991. He responded by creating an elaborate harassment campaign, sending anonymous threatening letters, making disturbing phone calls, and impersonating a private investigator to extort money from Silverman's family. The FBI arrested him in 1992 after tracing the letters and calls. The charges were federal, extortion, blackmail, using interstate communications to threaten. The tabloids had a field day. New York's chief judge, revealed as a stalker, was too good to ignore. But buried in the investigation's details was something more significant than personal scandal. Federal agents examining Wachtler's records discovered patterns in how he'd been assigning cases to specific judges on the Court of Appeals. Cases involving certain law firms mysteriously got assigned to judges known to favor those firms' positions. Cases involving corporate defendants were steered toward business-friendly judges. Constitutional questions that might establish progressive precedent went to conservative judges who could be counted on to rule narrowly. The assignments weren't random. They were strategic, designed to influence outcomes without appearing to interfere. The corruption wasn't bribery in the traditional sense. There's no evidence Wachtler received payments for case assignments. But he'd been using his administrative power to shape New York law by controlling which judges decided which cases. The practice was legal, technically. Chief judges have broad discretion over assignments. But Wachtler had turned discretion into manipulation, ensuring that the Court of Appeals ruled the way he wanted regardless of what the law might suggest. His trial focused on the blackmail charges, not the judicial corruption. He pled guilty, was sentenced to 15 months, and served 13 at a federal psychiatric facility. Upon release, he wrote a book about judicial reform and mental illness, reinventing himself as an advocate. The case assignments were never fully investigated. New York's legal community treated them as discretionary decisions rather than corruption, and Wachtler's successor inherited the same assignment powers with the same lack of oversight. That's the thing about systemic corruption. It survives individual scandals. Wachtler's blackmail got him removed. His case manipulation got quietly forgotten. New York moved on, but the structure that had enabled manipulation remained intact, waiting for the next chief, judge to decide how much discretion is too much. Los Angeles had a different problem. Their judges weren't manipulating cases. They were rubber-stamping perjured police testimony for years, convicting defendants based on evidence everyone knew was fabricated. The LAPD's Rampart Division was planting evidence, framing suspects, and lying under oath. The judges knew. They convicted anyway, for 10 years. 22. The Rampart Scandal Trials. The LAPD's Rampart Division was planting evidence, framing suspects, and lying under oath. The judges knew. They convicted anyway, for 10 years. Rampart was supposed to be an elite anti-gang unit, a specialized force deployed to Los Angeles' toughest neighborhoods in the mid-1990s. What it actually became was an organized criminal enterprise with badges, operating with the understanding that convictions mattered more than guilt, that statistics mattered more than truth, and that judges would believe whatever police testified to regardless of how implausible it sounded. The corruption was systematic, documented, and completely enabled by judicial complicity. Officers would plant drugs on suspects they wanted arrested. They'd fabricate probable cause for searches. They'd testify to events that never happened, describe evidence that never existed, and present cases built entirely on perjury. Then they'd appear in court, raise their right hands, swear to tell the truth, and lie with the confidence of people who had never been questioned before. The judges presiding over these cases had tools to detect perjury. They could assess witness credibility, notice inconsistencies, question improbable testimony. They could demand corroborating evidence, scrutinize police reports, and apply skepticism to rehearsed testimony. They did none of this. Instead, they treated police testimony as inherently credible, defense challenges as desperate tactics, and reasonable doubt as something that didn't apply when cops were testifying. Officer Rafael Perez's arrest in 1998 for stealing cocaine from evidence storage cracked the system open. Facing years in prison, Perez negotiated a plea deal that required him to detail Rampart's corruption. His confession revealed dozens of cases where officers had framed suspects, planted evidence, and committed perjury. He described the unit's culture of corruption as normalized, expected, and never questioned by the courts that processed their arrests. The cases he described followed patterns. Officers would stop someone they wanted arrested, usually in poor neighborhoods, usually Black or Latino defendants. They'd plant drugs or guns, arrest the suspect, write reports describing elaborate probable cause that never happened, and testify in court to the fabricated version. Defense attorneys would challenge the testimony, pointing out inconsistencies, questioning improbable details. Judges would side with police, ruling that officers had no reason to lie, that their testimony was credible, that defense challenges were unfounded. Dozens of defendants were convicted based entirely on this perjured testimony. Some received years in prison for possessing drugs that officers had planted. Others were convicted of gun charges based on weapons placed in their vehicles by police. A few were convicted of assault on officers during arrests, where the officers had initiated violence and then lied about who started it. The judges presiding over these trials included multiple Los Angeles Superior Court judges who handled criminal cases throughout the late 1990s and early 2000s. Their names are in case files, their rulings documented, their consistent pattern of believing police over defendants clear in the record. When the scandal broke, when it became undeniable that Rampart officers had been systematically lying, these judges didn't acknowledge their role in enabling it. Los Angeles responded by overturning convictions, reviewing cases, and eventually vacating over 100 verdicts tainted by Rampart corruption. The defendants were released, their records cleared, though many had already served substantial sentences. The officers involved faced varying consequences. Some were fired, a few prosecuted, Most simply resigned and moved to other departments. The judges faced nothing. No investigation into why they'd consistently credited obviously perjured testimony. No review of their other cases to see if the pattern extended beyond Rampart. No consequences for a decade of judicial complicity that had enabled systematic civil rights violations. Rampart revealed something uncomfortable about judicial corruption. Sometimes judges don't need to be bribed. They just need to be lazy, incurious, and willing to believe that maintaining conviction rates matters more than ensuring convictions are legitimate. That's not corruption through payment. That's corruption through abdication. And it's far more common. But abdication could at least be explained by incompetence or indifference. Sometimes judicial corruption was personal, targeted, and involved judges using their power as weapons. In Texas, one federal judge turned his courtroom into a private kingdom where sexual assault was policy. His name was Samuel B. Kent, 23. Judge Samuel B. Kent. Judge Samuel Kent used his courtroom like a private kingdom. The robes weren't just costume, they were camouflage. Kent was appointed to the federal bench in Texas's Southern District in 1990, presiding over cases in Galveston. His reputation was eccentric, temperamental, known for crude humor from the bench, and irregular courtroom behavior. But eccentricity in federal judges is often tolerated, even celebrated as personality. What Kent was actually doing behind that personality was systematically sexually assaulting his staff. The assaults began in the late 1990s and continued through 2007. Kent targeted women who worked in his chambers, case managers, secretaries, clerks, employees who couldn't easily refuse a federal judge's advances without risking their careers. The pattern was consistent. He'd make inappropriate comments, escalate to physical contact, then assault them in his chambers or courthouse offices. When victims tried to report, he'd use his judicial authority to block investigations. One case manager, Kathy McBroom, reported in 2007 that Kent had assaulted her multiple times over several years. She tried to file complaints with the courthouse's human resources, but Kent had intervened, claiming the complaints were workplace disputes rather than sexual misconduct. He'd used his position to access her personnel file, intimidate witnesses, and ensure that formal investigations were delayed or derailed. Another employee, Donna Wilkerson, came forward with similar accounts. Kent had assaulted her, then threatened her job when she tried to resist. The assaults happened in courthouse facilities during work hours, in spaces where Kent's judicial authority meant he was essentially unsupervised and unquestioned. The Fifth Circuit Judicial Council eventually investigated in 2007, finding Kent had committed sexual misconduct. He was initially sanctioned but not removed, allowed to keep his position with restrictions. The tepid response outraged victims and advocacy groups. Federal judges serve lifetime appointments, removable only through impeachment. The system wasn't designed to handle judges who used robes as weapons. Kent's response to the investigation was to lie. He submitted false statements to the Judicial Council, minimizing his conduct, denying specific allegations, and presenting himself as a victim of disgruntled employees. The perjury was documented, deliberate, and became the basis for criminal charges. He was indicted in 2009 for obstruction of justice based on his false statements to investigators. He pled guilty, was sentenced to 33 months in federal prison, and resigned from the bench before impeachment proceedings could conclude. He served his sentence and was released in 2012. The victims never received full justice. Kent's conviction was for lying about what he'd done, not for what he'd actually done. Sexual assault in federal facilities, when committed by federal judges, existed in a legal gray area where criminal prosecution was possible but rarely pursued. Kent went to prison for perjury. The assaults themselves were handled as misconduct, not crimes. His case revealed structural problems in judicial accountability. Federal judges have immense power over their chambers, minimal oversight, and legal protections designed to ensure independence that also shield misconduct. When judges abuse that power, victims have limited recourse, and the system's response is often inadequate, delayed, or focused on institutional reputation, rather than victim protection. Corruption takes many forms. Sometimes it's judges selling verdicts, sometimes it's judges enabling police perjury, and sometimes it's judges using courtroom authority to commit crimes they know will go unpunished because the robes protect them from consequences that would destroy anyone else. While American judges abused power individually, systematically, and occasionally with stunning brazenness, Italy discovered something worse. Their entire judicial system wasn't infiltrated by corruption. It was built from it. In 1992, investigators started pulling threads that would unravel decades of endemic bribery. They called it Mani Pulite, Clean Hands, 24. The Italian Clean Hands investigations. In 1992, Italian investigators discovered that their judicial system wasn't infiltrated by corruption. It was built from it. The investigation began with a single arrest. Mario Chiesa, a Socialist Party official in Milan, was caught accepting a bribe from a cleaning company seeking city contracts. Standard corruption, unremarkable in Italian politics. But Chiesa, facing prison, decided cooperation was preferable to loyalty. He started naming names, then naming more names, then revealing a structure of corruption so vast that prosecutors realized they weren't investigating a crime. They were documenting a system. Mani Pulite, Operation Clean Hands, expanded rapidly through 1992 and into 1993. What emerged was a network connecting politicians, business leaders, organized crime syndicates, and crucially, hundreds of judges. The judiciary, supposedly the institution that would prosecute corruption, was itself the most thoroughly corrupted institution in Italy. Judges at every level, magistrates, appellate judges, Supreme Court justices, had been accepting bribes from political parties, corporations, and the mafia. The payments were systematic, organized through intermediaries, and treated as routine operating expenses by those paying. Cases involving powerful defendants were steered to judges known to be available. Investigations into political corruption were quietly terminated by judges on payrolls. Appeals were decided based on payment rather than merit. The bribes weren't hidden in complicated shell companies. They were recorded in ledgers, documented in bank transfers, discussed in wiretapped conversations. The corruption was so normalized that participants barely bothered concealing it. Why would they? The judges who might investigate corruption were themselves corrupt. The system protected itself through collective complicity. Prosecutors documented thousands of cases spanning decades. Corporate cases where judges had ruled for whichever party offered higher payment. Criminal cases where mafia defendants received favorable rulings because judges were on mob payrolls. Civil disputes decided not by law, but by auction. The entire Italian legal system had become a marketplace where justice was merchandise and judges were vendors. Political fallout was immediate and catastrophic. The investigation brought down Italy's entire political establishment. Multiple governments fell. The Socialist Party, which had dominated post-war Italian politics, effectively dissolved. The Christian Democrats, similarly implicated, collapsed. Thousands of officials were indicted, hundreds convicted. The period became known as Tangentopoli, Bribesville, and marked the end of Italy's First Republic. But the judicial corruption proved harder to address. Judges investigating other judges created obvious conflicts. Many prosecutors in clean hands faced threats, both legal and physical. Some were themselves accused of corruption, whether legitimately or as retaliation. The investigation became a battle between reformist judges trying to expose corruption and corrupt judges trying to protect the system that enriched them. By 1994, the investigation's momentum slowed. Silvio Berlusconi, himself facing corruption charges, was elected prime minister and began systematically undermining the prosecutors. Laws were changed to make corruption harder to prosecute. Statutes of limitations were shortened. Immunity was expanded. The judges who'd been exposed largely avoided serious consequences. Some were removed. Most were shuffled to different courts. All kept their pensions. Clean hands revealed the ultimate form of judicial corruption. Not individual judges taking bribes, but an entire judicial system operating as a criminal enterprise. The investigation changed Italian politics permanently. The judiciary? It reformed enough to claim reform had happened, then resumed operations with more careful bookkeeping. Italy's lesson was clear. Expose 1,000 corrupt judges, and you'll change a few governments. But the judges will outlast the investigations, the reforms, and anyone naive enough to think clean hands stay clean for long. While Italy was documenting systematic corruption in its courts, America was producing judges whose corruption wasn't about money. It was about ideology enforced through judicial fiat. In Alabama, one judge was removed from the bench, not once, but twice. Not for bribes, but for believing his authority superseded constitutional law. His name was Roy Moore. We're past the halfway point. 24 cases, hundreds of corrupt judges, thousands of destroyed lives, 6 more to go, and they might be the worst yet. Subscribe if you haven't. You've come this far into the darkness. Comment, do you trust your local courts? After this, we're not sure we do either. 25. Judge Roy Moore. Most corrupt judges hide their contempt for the law. Roy Moore put his on a granite monument in the courthouse rotunda. Moore's corruption wasn't about money. It was about ideology enforced through judicial authority, the belief that his interpretation of law superseded constitutional precedent, federal court orders, and basic principles of judicial restraint. He was elected Chief Justice of the Alabama Supreme Court in 2000 Hollins, having built a reputation as the Ten Commandments judge for his refusal to remove a Ten Commandments display from his courtroom when he was a circuit judge. His first act as Chief Justice was to install a 5,680-pound granite monument of the Ten Commandments in the Alabama Judicial Building Rotunda. Not quietly, not as decoration, as a statement that Alabama's courts operated under biblical law first, constitutional law second. The monument included not just the commandments, but extensive biblical text, making clear this was religious doctrine, not historical reference. Federal courts ordered him to remove it. Moore refused. His argument was that acknowledging God was foundational to American law, that removing the monument violated his religious freedom, and that federal courts had no authority to tell a state chief justice how to manage his courthouse. The reasoning was creative, constitutionally illiterate, and completely in character. The federal order was clear, unambiguous, and legally binding. Moore continued refusing. In 2003, the Alabama Court of the Judiciary removed him from office for violating judicial ethics by defying a federal court order. The removal was unanimous. Moore framed it as religious persecution and launched a political career based on his martyrdom. He spent years fundraising off the monument, giving speeches, building a following among voters who saw federal judicial authority as tyrannical overreach. In 2012, he ran again for Chief Justice. Alabama elected him. Again, his second tenure repeated the pattern. In 2016, the U.S. Supreme Court ruled that same-sex marriage was constitutionally protected. Moore, disagreeing with this ruling, ordered Alabama probate judges to refuse issuing marriage licenses to same-sex couples. He claimed Alabama's constitution prohibited such marriages, that state law superseded federal court rulings, and that probate judges should follow his orders rather than the Supreme Court's. Federal judicial authority doesn't work that way. State officials can't simply refuse to follow Supreme Court rulings because they disagree with them. Moore knew this. He'd been a judge long enough to understand basic constitutional hierarchy. He just believed his authority, or his God, or his interpretation of both, mattered more. The Alabama Court of the Judiciary removed him again in 2016, this time permanently. He was 69, his judicial career definitively over. His corruption hadn't enriched him financially. It had enriched him politically, creating a brand based on judicial defiance that he'd monetized through speaking fees, book deals, and political campaigns. Moore's corruption was ideological rather than financial, but corruption nonetheless. He'd used judicial office to promote religious doctrine, defied federal court orders, and instructed subordinate judges to violate constitutional law. That he'd done so openly, proudly, and to cheering crowds didn't make it less corrupt. It made it more dangerous. While American judges defied law through ideology, judges elsewhere defied it through open venality. In the Philippines, corruption wasn't hidden behind granite monuments or creative constitutional interpretations. It was advertised. Justice had a price list. It wasn't negotiable. And business was booming. 26. The Philippine Judicial Corruption Crisis. In Manila, justice has a price list. It's not hidden. It's negotiable, and business is booming. The Philippines' judicial system operates with a level of corruption so normalized that attorneys discuss it openly, price sheets circulate among law firms, and judges negotiate fees as casually as they schedule hearings. This isn't historical. This is current, ongoing, and largely unaddressed by a government that benefits from keeping the judiciary for sale. The prices vary by case type and court level. Municipal courts handle smaller amounts, traffic violations, minor civil disputes, where bribes might range from a few thousand pesos to tens of thousands. Regional trial courts, handling serious criminal and significant civil cases, operate in hundreds of thousands. Appellate courts and the Supreme Court require millions, though at those levels the transactions are more sophisticated, routed through law firms and political connections. Attorneys know which judges are approachable and which require intermediaries. Some judges openly discuss their fees during pretrial conferences, explaining that favorable rulings require consideration. Others use bagmen, court personnel who collect and distribute payments. The system is so established that refusing to pay isn't seen as principled. It's seen as naive. Litigants who can't afford bribes simply lose. The correlation between wealth and favorable verdicts is statistically undeniable, documented in studies by Philippine legal reform organizations that operate under constant threat. Poor defendants in criminal cases face conviction rates approaching certainty. Wealthy defendants, even in cases with overwhelming evidence, walk free if they've paid appropriately. The corruption extends beyond individual cases. Judicial appointments are purchased through political connections and campaign contributions. Senior judges sell positions to junior judges seeking better assignments. Court staff supplement meager salaries by facilitating bribes, managing payment logistics, and ensuring smooth transactions between attorneys and judges. Reform efforts have repeatedly failed. Presidents announce anti-corruption campaigns. Judicial oversight bodies launch investigations, and occasionally, a particularly brazen judge is removed. But the system absorbs these reforms the way marble absorbs water, a brief darkening that fades by morning. New judges replace removed judges. Same prices, same system, just more careful about documentation. International organizations document Philippine judicial corruption regularly, ranking it among the world's most compromised court systems. The Philippine Supreme Court issues statements condemning corruption while its own members negotiate fees for favorable rulings. The entire institution operates in contradiction, publicly claiming reform while privately maintaining the marketplace. For Filipino litigants, especially those without resources, justice is simply unavailable. Not delayed, not difficult, unavailable. The courts exist, function daily, and process thousands of cases, but the outcomes are determined by payment rather than law, and everyone involved knows it. Montana had a different problem. Their courts functioned. Their judges followed procedure. But in 2013, one judge decided that a 14-year-old rape victim seemed older than her chronological age. The sentence, 30 days. The outrage, national. His name was G. Todd Baugh, 27. Judge G. Todd Baugh, 54-year-old teacher, 14-year-old victim. 30-day sentence. The judge's explanation was somehow worse than the verdict. Stacy Rambold was a teacher at Billings Senior High School in Montana. Charisse Morales was his student. In 2008, when she was 14, he began raping her. The relationship, if that word can be misused this grotesquely, continued until Morales' mother discovered it and reported to authorities. Rambold was charged with 3 counts of rape. Morales was placed in counseling, struggling with trauma that her therapist described as severe, persistent, and directly connected to Rambold's abuse. Before the case went to trial, Morales died by suicide. She was 16. Her death didn't end the prosecution. Montana law allowed the case to proceed based on her prior statements and evidence. Rambold entered a deferred prosecution agreement requiring treatment and supervision. He violated the terms repeatedly. The case went to trial. In 2013, Judge G. Todd Baugh presided over sentencing after Rambold's conviction. Montana law required a minimum 2-year sentence for sexual assault of a minor. Baugh had discretion within sentencing guidelines, but not below the mandatory minimum. He sentenced Rambold to 15 years, then suspended all but 31 days, with credit for 1 day already served. Effective sentence, 30 days for raping a 14-year-old student who later killed herself. The sentence was shocking. The justification was worse. Baugh explained from the bench that Morales was older than her chronological age, that she'd been as much in control of the situation as Rambold, and that the mandatory minimum sentence was inappropriate given these circumstances. He was victim-blaming a dead child from a position of judicial authority, and doing so as official sentencing rationale. The outcry was immediate, national, and sustained. Victim advocacy groups protested. Legal scholars condemned the sentence as both legally wrong and morally repugnant. Montana's Attorney General appealed, arguing the sentence violated mandatory minimums. Baugh issued a public apology, claiming he'd misspoken, that he hadn't meant to blame Morales, though his written sentencing memorandum contained similar reasoning. The Montana Supreme Court eventually ruled the sentence illegal, ordering Baugh to resentence Rambold to at least the mandatory minimum. By then, Rambold had served his 30 days and been released. He was later resentenced to 10 years, but had spent months free due to Baugh's initial ruling. Baugh faced judicial discipline proceedings. The Montana Judicial Standards Commission censured him, the mildest form of punishment available. He was prohibited from hearing sexual assault cases, but allowed to continue presiding over other matters. He retired in 2014, avoiding further consequences. His case revealed how judicial discretion, unchecked by oversight or accountability, enables judges to impose their personal biases as law. Baugh's corruption wasn't financial. It was moral, ideological, a belief that his assessment of a child's culpability in her own rape mattered more than law or basic human decency. Brazil's corruption operated on a different scale entirely. Not individual judges with biased views, but a systematic network where judges protected politicians and corporations for billions of dollars. They called it Operation Car Wash, and by the time investigators finished, they'd washed away any illusion that Brazil's Supreme Court was clean. 28. The Brazilian car wash corruption? They called it Operation Car Wash because that's where it started. A money laundering investigation at a gas station. By the time it ended, it had washed away any illusion that Brazil's Supreme Court was clean. The investigation began in 2014 with suspicious transactions at a Brasilia car wash and gas station. Federal police traced the money back to a currency dealer named Alberto Youssef, who was running a sophisticated money laundering operation. Routine financial crime, worthy of investigation, but not particularly remarkable. Then Youssef, facing serious prison time, started cooperating. What he revealed wasn't just money laundering. It was a corruption network spanning Brazil's entire political and judicial system. Youssef detailed a scheme involving Petrobras, Brazil's state-owned oil company, construction firms, politicians, and crucially, judges who protected the entire apparatus. Construction companies would overcharge Petrobras for contracts. Executives would skim billions. Those billions would be laundered and distributed as bribes to politicians who awarded the contracts, and judges would ensure that investigations never reached prosecution. The scale was breathtaking. Estimates eventually reached $5 billion in bribes, involving dozens of construction companies, over 500 politicians, and judges at every level of Brazil's court system. Federal judges, appellate judges, and Supreme Court justices had accepted payments to delay investigations, dismiss cases, or rule in ways that protected co-conspirators. Federal prosecutor Sergio Moro led the investigation with a team that grew from a handful of investigators to over 100. They used extensive wiretaps, documented money trails, and extracted cooperation from lower-level participants who provided evidence against higher-ups. The investigation proceeded in phases, each one revealing more corruption, each arrest leading to more cooperation, each cooperation exposing more judges. The judicial corruption wasn't subtle. Judges would receive payments ranging from hundreds of thousands to millions of reais, delivered through intermediaries or disguised as legal fees. In exchange, they'd issue rulings that protected defendants, delay proceedings past statute of limitations, or dismiss cases on procedural technicalities. Some judges provided advance notice of investigations, allowing targets to destroy evidence. Others simply refused to authorize search warrants or wiretaps that might implicate powerful defendants. Supreme Court justices were implicated through documented payments and wiretapped conversations discussing case outcomes before rulings were issued. The evidence showed a pattern where justices favorable to certain political parties would be assigned cases involving members of those parties, ensuring protective rulings. The court's administrative structure enabled this through case assignment discretion that lacked transparency or oversight. Brazilian politics convulsed. President Dilma Rousseff was impeached, though for reasons partially connected to the scandal. Former President Luiz Inácio Lula da Silva was convicted and imprisoned, later released when convictions were overturned on procedural grounds. Dozens of executives were convicted, hundreds of politicians indicted, and Brazil's entire political class faced accountability for the first time in decades. But the judges? They largely escaped. Some lower-level judges faced ethics investigations. A few were removed for particularly egregious conduct. Supreme Court justices implicated through wiretaps claimed the evidence was inadmissible or misinterpreted. The court, investigating itself, found reasons to avoid holding its own members accountable. By 2019, Operation Car Wash was effectively over. Moro had been appointed justice minister, then resigned amid controversy. Key witnesses recanted testimony claiming they'd been coerced. Convictions began being overturned on procedural grounds by the same judiciary that had enabled the corruption. The Supreme Court ruled that certain evidence was inadmissible, that investigations had overreached, that defendants' rights had been violated. Brazil recovered billions in assets and prosecuted hundreds of people. The corruption network was exposed, documented, and legally established, but the judicial reforms necessary to prevent recurrence never materialized. The judges who'd protected corruption remained on the bench, their pensions secure, their authority intact. Operation Car Wash proved that even when corruption is exposed comprehensively, even when evidence is overwhelming, even when public outrage demands accountability, the judiciary can protect itself. Because judges write the rules, interpret the evidence, and decide what justice means. American judges don't face corruption on that scale, but they face something perhaps worse. The corruption of believing class determines justice. In 2016, one judge gave a 6-month sentence to a Stanford swimmer convicted of rape. The victim impact statement went viral. The sentence did not. His name was Aaron Persky. 29. Judge Aaron Persky. Brock Turner was convicted of 3 counts of sexual assault. Judge Aaron Persky worried about his swimming career. The victim impact statement went viral. The sentence did not. The assault happened in January 2015 at a Stanford fraternity party. Brock Turner, a 19-year-old freshman and competitive swimmer, assaulted an unconscious woman behind a dumpster. 2 graduate students on bicycles saw it happening, intervened, and held Turner until police arrived. The evidence was overwhelming, immediate, and witnessed. Turner was arrested at the scene. His trial in March 2016 was covered extensively, but not unusually so. Sexual assault prosecutions at elite universities had become depressingly routine news. Turner was convicted on 3 felony counts: assault with intent to commit rape, sexual penetration of an intoxicated person, and sexual penetration of an unconscious person. Each count carried potential prison time. Prosecutors recommended 6 years. Judge Aaron Persky presided over sentencing in June 2016. He'd heard testimony from both sides: the victim's impact statement, Turner's family's pleas, character witnesses describing Turner as a good student and talented athlete. Persky had discretion within sentencing guidelines. He chose to exercise that discretion in ways that revealed exactly whose futures mattered to him. He sentenced Turner to 6 months in county jail, 3 years probation. His reasoning, stated in court, focused on Turner's age, lack of criminal history, and the impact that a lengthy prison sentence would have on his future. Persky expressed concern that prison would have severe impact on Turner, that this was a case where probationary sentence is appropriate. He noted Turner's remorse, his previous good character, and yes, his athletic achievements. The victim had written a 7,000-word impact statement describing the assault, the trial, and the devastating effect on her life. She'd read it in court. It was raw, powerful, and would later be read by millions when published online. Persky had heard every word. His sentence suggested he'd weighted Turner's swimming times more heavily than her trauma. The statement went viral. Public outrage was immediate and sustained. Legal scholars noted that 6 months for 3 felony convictions was extraordinarily lenient. Statistics showed that Black and Latino defendants convicted of similar crimes in the same jurisdiction received sentences averaging years, not months. The disparity wasn't subtle. Persky's sentencing pattern showed consistency. In cases involving privileged defendants, wealthy, white, educated, he tended toward leniency, emphasizing rehabilitation and the impact of incarceration on defendants' futures. In cases involving poor defendants or defendants of color, he applied guidelines more strictly, emphasizing public safety and deterrence. The pattern was documented, statistical, and defended as judicial discretion. California voters recalled him in 2018, the first judge recalled in the state since 1932. He claimed the recall undermined judicial independence, that judges needed discretion to make individualized sentencing decisions. His opponents argued that discretion exercised exclusively to benefit privileged defendants wasn't independence. It was bias wearing robes. Turner served 3 months of his 6-month sentence. His conviction stands, his name permanently associated with the case. The woman he assaulted, who remained anonymous throughout the trial and for years after, eventually identified herself as Chanel Miller and published a memoir. Persky lost his judgeship, but maintains he'd done nothing wrong. Class-based justice isn't always corruption in the traditional sense, but when judges consistently value wealthy defendants' futures over poor defendants' rights, when privilege determines sentencing more than crime, The corruption is structural, pervasive, and perhaps more damaging than bribes. China addressed judicial corruption differently. They executed judges for it, then appointed new corrupt judges. The system wasn't broken. It was working exactly as designed. 30. The ongoing Chinese judicial corruption. In China, they don't hide judicial corruption anymore. They execute judges for it, then appoint new corrupt judges. The system isn't broken. It's working exactly as designed. The Chinese Communist Party launched its latest anti-corruption campaign in 2012 under Xi Jinping, promising to catch both tigers and flies, high-ranking officials, and low-level bureaucrats. Thousands were arrested, hundreds executed, and among them were judges. Lots of judges. Judges who'd accepted bribes to fix cases, to delay investigations, to protect the party officials from prosecution. The campaign was thorough, public, and completely performative. Because the problem wasn't individual corrupt judges. The problem was a judicial system designed to serve party interests first, law second, and justice whenever convenient. Chinese courts operate under Communist Party supervision, their decisions subject to political approval, their independence limited to cases where independence doesn't threaten power. In this structure, corruption isn't deviation, it's function. Judges accept bribes because judicial positions are purchased through political connections and party loyalty. Appointments require payment. Promotions require payment. Favorable case assignments require payment. The entire system operates as a marketplace where judicial positions are investments that must generate returns. Accepting bribes from litigants is how judges recoup the costs of their appointments and fund their next promotions. The cases are documented, prosecuted, and publicized. The party announces each wave of arrests, each execution, each conviction. State media presents these as evidence of the party's commitment to fighting corruption. What they actually demonstrate is that corruption is so endemic, so structural, that no amount of executions can eliminate it. Executed judges are replaced by new judges who operate in the same system, face the same incentives, and respond to the same pressures. Some are more careful, having learned from predecessors' mistakes. Others are equally brazen, betting they're protected by the right connections. All understand that their primary loyalty is to party directives, not legal principles. Western observers document Chinese judicial corruption regularly, cataloging bribes, tracking executions, noting patterns. But the documentation misses the point. Chinese judicial corruption isn't a problem the party wants to solve. It's a tool the party uses to maintain control. Corrupt judges are vulnerable judges, subject to prosecution whenever politically useful. The threat of corruption charges keeps judges compliant with party interests. The system perpetuates itself. Anti-corruption campaigns remove judges who've become liabilities, replacing them with judges who'll eventually become liabilities themselves. Corruption remains constant. Only the faces change. China executes corrupt judges at a rate that would empty most Western court systems within a year. And still, the corruption continues. Because the problem was never individual bad actors. It was never about a few rotten judges in a healthy system. The 30 cases here span 3 centuries, 6 continents, and legal traditions from common law to civil law to authoritarian control. And the pattern is identical. Power protects itself. Robes conceal rot. And justice, when it's inconvenient, is always the first casualty. These aren't the famous cases. They're not Dred Scott or Plessy v. Ferguson, the corruption that made history books. These are the cases that made money, made careers, and made sure the system stayed exactly as corrupt as it needed to be. And so the list ends, not with justice served, but with justice sold. 30 times over. In courtrooms that promised fairness and delivered fraud. By judges who swore oaths and broke them before lunch. Sleep tight.